Good morning and welcome to Defense Tires. I'm your host, Bob Mata, and I am bathed once again in sunlight as we continue our coverage of the Commonwealth of Massachusetts versus Karen Reed. They're back up in court today. I'm not exactly sure what's popping today. So it's interesting. So I am interested to see what exactly is going to happen. I've been trying to look for a filing. I haven't seen anything necessarily. I saw one thing filed yesterday. I've seen speculation on Reddit, but whatever it is sure to be very, very interesting. If there's one thing we've learned about this case is that it is insane. That we know. It is absolutely insane. So I'm gonna try to find where it's streaming. Like Court TV says it's due up in a few minutes. So maybe I'll keep an eye on this and we'll see what's up. Yeah, and I know that Aiden, his case is up. I did see what was filed by Tim Bradle in his case. So if I can find that, I'd like to cover that as well to see what's popping in that one. That one's always more challenging to find. I've got to find once Allie gets on with me, I've got to try to figure out if I've got that Zoom link still. So I will. Oh, did she dip by? we got an early morning client call from a potential client with an interesting story. Very anti-police. So of course my ears perked up. I was like, you have my attention. And then of course I passed the phone off to Allie. So kind of news that we didn't cover yesterday when we were on our live with Dr. Scott and Dr. Shiloh. I might have mentioned it towards the end. We did hear back from the U.S. Court of Appeals, First Circuit, and they have denied Karen Reed's appealing the denial of the writ, seeking for them to find that she in fact was acquitted, that there was a verdict rendered as to counts 1 and 3. That was denied. Obviously, the stay that went along with that was mooted out because obviously the case is no longer in front of them, so they're not going to need to worry about that stay. Now, whether or not they're going to try to move it up to SCOTUS on an emergency basis, I have no idea. I mean, it's certainly got some heavy duty rights involved with it, with the double jeopardy, potential double jeopardy issues that are very much a thing. And frankly, I think it's something that needs to be dealt with. I mean, you can't have this happening. I get that the law in Massachusetts, as it's currently stated, does not have a place for what happened in that last trial in terms of how the jury was reaching a decision and confused about the verdict forms. And ultimately they end up unwittingly saying that they couldn't come to a conclusion on anything unanimously, therefore all of it was kicked. And now that we've heard from multiple jurors that that is not the case, that they were absolutely positively unanimous on counts 1 and 3, with one being the one that you're worried about, which is the second degree red rum charge. It's a real problem. It is a real problem. So, I mean, we'll just have to kind of wait and see. I mean, time is short. This thing's starting on the 1st, Tuesday. So, but I mean, either way, no matter what goes on with that, if something is filed, which I imagine it would, if there is going to be anything filed, it would probably happen today, at the latest Monday, if they need to take the weekend to try to prep. But I mean, we'll see what happens. We will see what happens. All right, I'm gonna check. What do you guys think? Is Boston 2, 10, or 25 the best in terms of kind of figuring out what I'm gonna try? Boston 25 is usually pretty good. Boston 10 is usually pretty good too. Let me see. Let's see if they got anything. Yeah, I'm not even seeing anything on there. So Boston 25, I'm not seeing anything. Let's see what they're saying on Boston, CBS Boston. All right, I'm not seeing anything there either. Let me check Boston 10. All right, I am not seeing any live setup on any of those. So we're just gonna keep watching, see what goes on with Court TV then. That's what we gonna do. That's what we gonna do. Um, I'm not seeing it in Law and Crime either, that they've set it up for it. Oh wait, take it back. Okay, you right. Thank you. Thank you. Thank you. Thank you. Thank you, Alessis Binder and others. All right, we've got the OnlyFan, which is not working right now. It's not operating. It's nothing more depressing than not seeing OnlyFan in action. I imagine that will be the very first thing that Judge Bev does, is tells them to kick that fan on immediately. All right, so here we are. We are live.
Yeah.
See what we can hear in here at hot mics.
But I'm gonna go on Zoom.
I want to try to find Aiden's
Attorney
thing.
Cosgrove, do you want me to call security? All right. You let me know. You let me know.
Okay, so we know right now, you heard them talking about Cosgrove. Cosgrove is prosecuting Aiden.
Exactly. Thank you. Thank you. I would have too. Should I just sign in on my laptop? Sending it to Zoom, or should I just shut up and let you do what you're doing? Okay. Yes. All right, so now I can just go zoom. All right.
Welcome to Zoom for Government. Enter your meeting ID followed by pound.
And by the way, Chris, I couldn't find you. I found the other one. I did. But I led you.
Enter your participant ID followed by pound. Otherwise, just press pound to continue.
They used it last night for that.
You are in the meeting now. There are 13 participants in the meeting. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting. You are muted.
I think I'm all set. Oh, is there ready?
You are unmuted.
Can you hear me?
Yes.
Judge, I'm not a cat. My assistant put a filter on. Judge, I'm not a cat.
No, sir.
Whoa. We're entering the Matrix. This is what it sounds like behind the scenes entering the Matrix. We're going into Dedham world. Real weird. All right. All my boots on the grounders, all my diggers out there. Can you guys see if anybody's been able to find these cases? I think they're both going to be Cosgrove's in here. I think potentially the
You are
defendants are
muted.
going to be zoomed in, but I think that the lawyers might be here. The lawyers might. I'm sure Jackson's going to be zooming in. I don't think he would have flown in, but David might be here. Can't hear me?
Can you record it with the monitor on you?
We're sorry. All circuits are busy. Please try again later.
You are unmuted.
We're sorry.
Yeah,
all circuits are busy. Please try again later.
Is that a new one, Mandy?
You are muted.
Mandy's really bulking up on the sound clips. Wow.
Strike three. You're out.
Like that one.
You are unmuted.
Mute again.
You are muted.
Oh man.
To tell you I'm happy to be here, but why start with an untruth?
I am Sleuthy. Playing with the new toys. Playing with the new toys. You know, my kids got me this little baby dude. So I can like set it up with what my favorite sound bites are and then just play it. It's fancy. It's been sitting here since Christmas. This is my tech wizardry. It seems intimidating. Thank you, Streets of Bakerfield. Appreciate that very much. Lisa Shelton, appreciate you gifting 10 DD memberships very, very much. Feminem, love that handle. Aw, family hug. Jesse, 4 months. Aw, family hug. Lisa coming back. Should we grab our popcorn? Always. Is there ever a hearing that you shouldn't have your popcorn during this case? I think not. I think not. A little early for the
You
beverage.
are unmuted.
Maybe. Maybe
Hold on
not.
for a sec. Muted.
5 months. Has it been 5 months, Lisa? I remember when we were chatting it up the first time in the courtroom.
You are
Hey,
muted.
look, Delphi. 5 months flown by.
You are unmuted.
Unmute you again.
Julia, what does that robot think she is
You
saying
are
that we
muted.
cannot talk? You tell him, Julio. Thank you for that, Streets. Appreciate you very much.
It's coming out of here. I muted everyone.
All right, we're still going here. Still going. Mandy, you gotta block that lawn crime, girl.
Okay.
Do your magic. Do what you do.
Can you,
Take care of the business. I mean, I'm assuming we're gonna hear a little something from Hanky
take care of it after this?
about if he's got some kind of beef with Victoria George coming on as a consultant. I don't see what he can say. Karen Reed's allowed to hire whoever the hell she wants to hire.
What? I think
Okay, see a head there? A little bit of a head. I don't remember that game. I'm a board game playing fool.
Welcome to Zoom for Government.
Ooh.
Enter your meeting ID followed by pound.
Oh, who's good with remembering what the
Enter your participant
numbers
ID
were on the old
followed by
telephone phone?
pound. Otherwise, just press. You are in the meeting now. There are 12 participants in the meeting. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting.
Yeah. You guys remember that? I always used to try to figure out numbers. Like, okay, that sounds like a 7. That was a 9. That was a 2. Wait, play it again. That was definitely a 2. Wow, it was some pretty groovy.
You are muted. You
This
can
day and
mute
age,
or
right?
unmute
They have
yourself
like some
by
dope
pressing
music
star
on,
6.
like waiting music. Why does it have to be some horrible shit like that? All right, good. Well, we have a second, and we're waiting. I want you
You
all.
are muted.
If you're somebody who fancies
You are
funky
unmuted.
Can everyone
fictional,
hear me?
yes, we can hear you, sir.
I am not a cat, Your Honor. Judge, I'm not a cat. I'm ready to proceed.
Jim, just so you know, we hear a big echo. I think two people might be in the same room, and that might be causing it.
Is it me? Yeah, exactly, Afton. It was either calling in song requests or trying to win a contest for tickets to a concert that I would never win. That's me doing the cat. Haven't you ever seen the cat video, Mavhawk, with the lawyer? It's the greatest. It's the greatest YouTube of all time. It's the best thing to come out of COVID of all time. It's amazing. It's a lawyer is in a Zoom with an old head lawyers. Zoom was a very, very tough thing to figure out, but his assistant put on a cat filter. So, oh no, I gotta. Don't worry about. I'm on live. What's in there? Oh yeah, yeah. Sorry.
You are muted.
Unmute yourself.
You are unmuted.
Do we still have the echo?
I'm gonna stop the cam so Gloria's not put on blast.
It's a little better.
Do you have an echo?
I think it's there anymore.
It's gone.
Okay. All right, I'm all set.
All right. If you're all set, why'd you turn off the camera, Chief? Oh boy. All right.
Hey, Paul.
Oh, there we go. There we go. Oh, I heard stank.
Folks, make sure your cell phones are off and put away for me, please. Thank you.
Be great. It would be great if Hank was the cat lawyer. All right, let's go. Let's see what's up. All right, so Cosgrove's in there, no Bradle.
Judge, this is 22117 and 23313, the Commonwealth versus Karen Reed, and separately the Commonwealth versus Aiden Kim. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please. Sure. I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
What a lovely clerk that guy is, huh? None of the lawyers are there, other than the Commonwealth. There's Timmy. There's Timmy Bradle. There's Hank.
Your Honor, I respect Miss Reed's rights, and I want her to have all her rights protected, but I need all of her private communications with her lawyers, Judge. I just need them.
Okay, Mr. Clerk. You may
Judge,
call the
thank
case
you.
and identify the parties.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aiden Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradle for Aiden Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradle. Good morning, Mr. Kearney.
And Mark Federer for Mr. Carney. Good morning, Your Honor.
What's up, Marky?
Good morning, Attorney Federer.
All right, Hank did not comb his hair this morning. Dude just rolled out of bed. Breaking news.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so. Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. Wow. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Bradel, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay,
Okay, so Hank is going to try to sell the story that he doesn't think that Aiden was texting with his lawyer in the middle of this case. Does anybody buy that shit? Does anybody buy that shit? I sure hope the judge doesn't, because that's some bullshit.
Specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question, because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys. Mr.
Oh, you are
Mr.
so
Federer.
fucking
Okay,
full of
well,
shit.
we all agreed, counsel, that those in fact would be privileged communications
course.
without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case.
What about all your consciousness of guilt bullshit, Brennan? What about all that? This guy is so full of shit.
Docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 and on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date. But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It's suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Carney and Ms. Reed.
I'll stop you right
Nothing
there,
about
Attorney Bradle,
lawyers
because you
or
raised
third
an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Carney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Carney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank
So
you,
the fact that
Attorney Brady. I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between defendant Reed and Kearney and defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
It's got to be a taint team. It's got to be a taint team. It just can't be the prosecutor's office. It has to be a taint team, because if there's Bradel Kearney communications, those can't be turned over. It has to be a taint team. I don't trust any of these bastards to be going through. Oh, yeah. Yeah, there were a couple of communications, but I don't know what they were. Give them the wink and nod bullshit.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Bradel. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Bradel. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. This is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit, and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Cannoni specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibit, Judge, these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Cannoni's suspenders?
I think so, Judge, because we need one. And we need one as to this specific information. these three people have repeatedly stated that that they're privy to inside information. And, with respect to Mr. Carney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these two different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these three people must stay away. And a general order as well as part two is my part two. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Little, Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, et cetera. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detailed, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case
that has disseminated any information
Yeah, as far
improperly.
as
I
you
would not
know.
allow it or tolerate it if it happened.
This
I
guy's
want
so
that to
full
be
of shit.
crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney
Your Honor,
Cosgrove. Thank you,
Can I speak to that,
counsel.
can I
No,
speak to that
we are adjourning the hearing now. Thank you, counsel.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Goodbye.
Court is now in recess.
So there you go. Big fan of I think it's pronounced Sistitsky. It's Sisitky. Sistitsky. Sistitsky. I think that's how it's pronounced. Judge Sistitsky. It's a mouthful. Sistitsky. Whatever, however you pronounce it, I'm a big fan. I'm a big fan. But I know it's Sisitky. How do you guys think you say that? Whatever the case may be, dude's a baller. Dude's a baller. I love every judge out there that actually gives a shit about the Constitution, and he clearly does. So that was great. Hank got shut down. He got pantsed. He came into court with his hair unkempt, just rolled out of bed. Must have overslept. Must have overslept. Must have been up late trying to hatch plans on how to fuck Karen Reed and overslept, slept past his alarm, woke up in a panic. It's like, oh my God, I gotta get my fucking suit on. All right, I'm trying to comb my hair. And then crawled over, slimed over to the courthouse with his hair looking a mess. That was the best part, aside from the judge telling him, well, you know, I had a very specific order. And come to find out, there might be communications between Aiden and his lawyer. That's a problem, Hank. That's a problem. That is a problem. All right. So essentially, that has been very limited in terms of what they're going to get. Nothing should be looked at. And look, y'all, I don't trust the taint team either. I mean, taint teams are just other prosecutors. So, you know, I think the taint team should be defense lawyers. not the defense lawyers in the case, but defense lawyers that are not in any way associated with the prosecutor's office, because I just don't trust them. It's that simple. Here, anywhere. Sorry, just don't trust y'all. You're all on the same team, no matter where you're at. You're all on the same team. So, all right. That was short and sweet. It was a blast, though. I had so much fun. We had a great crowd in here. I'm trying to think. I'm coming back at some point. I think I'm going to probably make it a little earlier. Mandy's pissed at me. She's like, I put out the weekly schedule, and like, I think all week our times have been off. It's really, I got ahead of myself in terms of scheduling before I like confirmed when my guests could show up. So don't be mad at me, Mandy, and you guys don't be mad at me. Schedule is important.
All circuits are busy. Please try
Oh
again
boy.
later.
Oh boy. And Mandy's giving me the business. So keep your
You're out.
Like, I'm definitely going to cover I mean, the trial's coming, y'all. There's no stopping it. There's no stopping this thing from starting April 1. They will be selecting a jury. The question of how long it's going to take to do that in this case, we need to have a wager. We need an over under. We need an over under on that, because this case, finding unbiased jurors in this case, or jurors that have not heard about this case, number one, and number two, have not formed an opinion on this case, is going to be near impossible. I mean, this jury selection could take weeks. Like, honestly, It really could. And as far as I know, they did not stream voir dire in the first trial. So we're going to have to, I'm assuming that there will be some reporters in the courtroom. We'll have to be actively monitoring Twitter or X to see what the deal is, kind of get the blow by blows there as to what is going on. I agree. Alessi never sleeps. They do need a jury of black women. I think every jury should be all black women. If I had my choice, I would pick every jury to be all black women because they're fucking straight shooters all the time. So, but I could not agree with that sentiment more. So yeah, there we have it. Not a ton happened. The judge basically reinforced what he had previously ordered, which was any communications that are going to be turned over can only be between Aiden and Karen. Bradel sounded very secure in the fact that's much ado about nothing. And the judge also acknowledged that Canoni the other day, excuse me, all had shut down Hanky with respect to communications. So he's going to bootstrap her order with his order. Oh, big time. Big time. I mean, if y'all know my history, that is truth. That is absolute truth there, Gray Space. I am definitely a stand of black women. So I think that it was a successful day in court today. I think it was a very successful day. I like, even though it was limited in terms of pantsing Brennan a little bit, it was delicious, wasn't it? Even just seeing him getting slightly swatted on the behind was delicious. Absolutely delicious. So, all right, you guys, you're the best. We had a great crowd. Please, on the way out, make sure you like, share, subscribe, get the word out. We're a pretty good channel. We think that we've got some. And I didn't even have the better half with me, Allison. You know, I mean, she would have been popping off. We both would have been popping off. I enjoyed that though this morning. That was a nice way to start a Friday. Nice way to start the weekend. Nice way to kind of move into this trial. And this trial is going to be a banger. Man, this could be the trial. It's definitely going to be the trial of the decade. I don't know if it'll beat OJ because OJ was insane, but it's going to be goddamn close. This is going to be goddamn close. This thing, it's going to have everything. It's going to have everything. I mean, I think that the one X factor is if they're going to try to file an emergency motion with the Supreme Court based on this issue. Because, and what I'm talking about is the writ of habeas corpus that was filed over on the federal side, wherein they were trying to get the federal side to sound off on this, because the reason it goes over there is because we're talking about constitutional rights that are being impacted, and namely the double jeopardy issue that has arisen in this case. Because I don't care what anybody says, it is unequivocal to me at this point. We have heard from enough jurors that it is clear. Affidavits are not, because we've seen the letter from Victoria George. We've seen and heard Ronnie. They all agreed. They all came to a unanimous decision that she was not guilty on counts 1 and 3. That was the leaving the scene, and more importantly, second degree unaliving or red rumming. That was a major issue. And it's a major issue moving forward. I mean, we can't have a law in place. And the problem is that the law as it's currently situated in Massachusetts and in many states is that if the jurors don't come out and the verdict is not recorded on the record, it's as if it doesn't exist. So we've got this issue here. where we know that a juror, an impaneled jury, heard all the facts, went through all the deliberations, and actually came to a decision on 1 and 3, but didn't know how to fill out the form. They thought it was an all or nothing proposition, which, by the way, is exactly what Alan Jackson was arguing. And if you guys don't know what I'm talking about, you go back. See, people get bored with jury instruction conferences. You shouldn't. We told you during that trial, they are absolutely critical. Making sure that those jurors understand what is going back to them in the form of the directions, the instructions that they're getting on how to handle deliberations, on understanding what the charges are, what those statutes require the state to have proven beyond a reasonable doubt is critical. And we saw it here. And if you don't know what I'm talking about, that's when Jackson was telling her, please, Your Honor, I need you to change the way that these verdict forms read, because it's not giving the jurors a choice. And the judge gave huge pushback. She's like, no, it's like, it doesn't, it's got guilty. We can infer if they don't check guilty that they're saying that she's not guilty. Well, no, you can't. Now you know. So that issue, I think, is powerful enough to make its way up to SCOTUS. Now, the way it works with the Supreme Court of the United States is they have to grant cert. Okay. That means that they're saying, okay, we've looked at the preliminary allegations, what the preliminary issue is. We think it's something that we need to address. And then they'll direct the trial court to send the record to them. And then they'll look at it and then they'll reach a decision. And then once SCOTUS rules on something, it becomes the law of the land. Remember, the way that it works between federal law and the state laws, the states can give more protection than is provided by federal law, but they cannot give less. Okay, that's your rule of thumb. So I just want you guys to remember that. Whether or not anything's getting filed on that, I have no clue. Frankly, I'd be a little bit surprised if it wasn't. You know, we'd see it on their shadow docket if it's going to pop up. So maybe, keep taking a poke at that. CJ Drake, I mean, I get where you're coming from in terms of, some of the things that are going on recently. And I tell people all the time, and I don't get into politics on our channel at all. But Alice and I are always telling people, look, whoever's president is basically just a figurehead. The power is split amongst the legislature and obviously the presidential seat, whoever's sitting in it. But the reality is the most important thing that comes out of whoever's elected president is who they are appointing to the Supreme Court of the United States. Those are lifetime appointments, and they make the law of the land. Make no bones about that. Like the thing that you guys should always be researching, depending on what matters to you, like personally, whatever matters to you, you should look at if there's going to be any Supreme Court seats that might be opening up. If you've got some real old justices up there that are like in their 80s that might be retiring at any moment, and you've got seats that are opening up, or they're at an advanced age where you have to worry about their health, because that is so critical in terms of what happens in our country, because they make the law of the land. Because the way that it works is state legislatures, they draft House bills. House bills then have to get through the House and the Senate. If they get through the House and the Senate, they then get thrown on the governor's desk. If the governor signs off, that statute then becomes law. Once a law is made, that law is put into practice, meaning that if it's a criminal statute, it's now going to be litigated. And so when it's in practice, because it's sometimes lawyers, sometimes not, it's the people that you vote for your House and your Senate and your state are crafting those bills, those House bills. So, but they don't know how they're going to work once they're out in the real world. So once they get out in the real world, or if there's issues that lawyers feel that once they're out in the real world impact the Constitution and our constitutional rights, that's when you see litigation start to happen. And that's when ultimately things that are fought in a state at first will ultimately make their way over to the federal track and make their way up to the Supreme Court of the United States, because they're the ones who are the final arbiter on what the fuck's going to happen with that law. And then whatever they rule, that's it. Unless somewhere down the road they rethink it. I don't have my phone, Trace. Let me see. What are they, Trace? Let me see. Tracy said she sent me some stuff just now. I don't see anything. When did you send them, Trace? Tell me in chat. I'm not seeing the email yet. I don't know what it is. I don't know what it is. Let's see. Yeah. Yeah. Hold on, y'all. I'm checking to see what Tracy's saying. She sent over. Man, yeah, Mandy, throw Tracy's comment up there. I'm not seeing it. All right. So before I dip, I'm going to thank you all again. Lisa, I thanked you, but I'm going to thank you again for gifting 10 DD memberships. We love members. We love members so much. Jesse, member for a month. Oh, family hug. You rule. Feminem, new member. Oh, number one. That's an amazing screen name. Number two, thank you for becoming a family member. Ah, family hug. Lisa went through that one. Thank you, thank you, thank you. 5-month member. Thank you, thank you, thank you. Julio, thank you again. Streets of Bakerfield, thank you again. Papa G coming through 5 minutes ago. Okay, but what is it about? I'm not seeing it in my email. Papa G, $20 holla. I'm curious to see the new attorney joining the team. There's a motion from the defense that just, oh shit. All right. All right, let me check the email. I don't know why it's not showing up. It's bizarre. Huh. Let me try get new mail. Huh. Oh, there it finally came through. Okay. Oh boy. Let's see.
2 hours later.
Got up, Mandy. All right, let me see. Okay, let me pop these dudes up. See what's what. Okay. 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 All right. Okay. Well, while we're here, I mean, let's go through them. Let's see what's what. Let me finish these though. Papa G, thank you very much. I'm curious to see the new attorney join the team. Thanks a lot. From my understanding, sounds like she is going to be a jury consultant, which is fantastic. Can't think of a better jury consultant on this case than a former juror from this case. I cannot see anything that can then like I'm sure Hank has been feverishly trying to find a way to keep her off, but I don't know that it exists, buddy. Kimber, new member. Oh, family hug. Welcome. Welcome to the fam. Kaylee, bunch of new stuff is hitting the docket. We just got it. Thank you. Thank you, Kaylee. Anita Whiteclaw, gifted 10 DD memberships. Thank you so much. Appreciate that. Spank Hank. Got a little spanking, got a little paddling. I don't think it was a pants down paddling. You know, it was over the pants, just the hand Certainly was. He didn't get the belt, right? Nobody told him the judge didn't instruct his bailiff to go pick a switch off the tree. You know, that didn't happen, but we'll take what we can get, right? Julio, not in Bev's court now, Hanky. I mean, actually, they were, but Bev wasn't on the bench. Thank you for your generosity there. Hank's whiny objectifications. Hank can't snake his way in this court. Didn't seem like it. Sistitsky, just never get it. I'm gonna have to watch a YouTube video. Like I saw when he was getting sworn in. I pulled him up because I liked him the first time I saw him. I'm like, this guy's all right. Thank you for your generosity. I have grave concerns. I have grave concerns. Bet you do, Judge Bev. Thanks, Julie. Janie Trioli. This guy gets all my angry going. Me too. Pisses me off. Defense bar guy. Turncoat. Perfect. Per Benedict Arnold. That's what he is. Just south of history. Defense attorneys are real superheroes. Boom! Love you, Just South. Appreciate you and your generosity. Both. Nightclubs, can you break down what happened? I hope I did. I hope you got it. Essentially, like thumbnail, judge was concerned that what ended up being tendered or was going to be tendered was going to include attorney-client privilege material. Judge wanted to make sure that that wasn't happening. Cosgrove tried to say, hey, we need all the group chats. I'm not a cat. We need all the group chat. Judge shut it down. Said, no, you're not getting all the group chats. What you're going to get is exactly what I ordered. And that's it. So that's the thumbnail, what went down there. Opinion on Proctor, Taint team, one prosecution, one defense, one judge. Agree. Thanks, Pinnett. Amy K. OG. Boots on the ground in mass. I'm seriously considering. See, here's the thing. Like, I don't think I'll be able to get in the courtroom, but Allie would stream the trial. My boots on the ground shit's pretty good. And I think there's a lot of content. Like, if you haven't seen my boots on the ground from the Delphi case, I suggest you check it out. It's pretty good. I'm pretty decent on the boots on the ground shit. It's kind of my wheelhouse. I enjoy doing it too. So I'm definitely considering it. Thing is, it's like I'm torn. I don't want to miss what's going to be going on in the courtroom. You know what I mean? It's like I guess I could watch it somewhere. Probably hole up with somebody. I know a bunch of my friends, a bunch of lawyers are going to be out there. Vinny's going to be out there. I think Michael Bryant's, Linda's going to send him out there for boots on the ground. Poor Michael. Linda will be like, you need to go out there, Michael. You need to get into that courtroom. Love Linda and Michael. Okay. We've got Hanky Bedhead, no doubt. Thank you, Megan. Keep up the fab law, but I mean, we ain't going anywhere. We're so close to 40,000, y'all. I hope that people are like liking and subbing. I'm telling you, we've got good content over here. We the truth. Thank you so much for that gifted DD membership. Amanda, we always love you. S. Rains, new member. Family hug. Harry Potter's beard. Thank you for becoming a new member. All right. So while we're here, I think that it would make the most sense to see what was filed, right? Let's just go through it. See what's up. That's what we do anyway over by here. All right. So the first thing, this affidavit, now I don't know what order I'm going to do them in here though. Let me peep what's what. Okay. Let me get to the end. Okay. So we've got defendant's motion for specific discovery. It's a 4-pager. We've got affidavit of counsel in support of Commonwealth's motion to compel reciprocal discovery of the ARCO. Hank's still going at it. Still trying to weasel his way out of getting ARCA. Like, dude, they're testifying. Get a grip. Deal with it. They're testifying. Don't worry, dude. You got your weatherman in. The ground was rock hard. Ground. Yeah, I don't know how that jives with their theory, though. I mean, if it's rock hard, like, where's the blood? I mean, anybody who has ever had a head wound, you bleed like a stuck pig with a head wound. All right, so this is the most lengthy. Okay, so there you go. Hank was sniveling about some reciprocal discovery, and the defense is saying, "Here we go. This is what we got, bro." All right, so this was filed today, the 28th. I think today's the 28th. So this was filed this morning. So let's see what they're saying they're turning over to Bedhead Hank. See what we got. So the notice of reciprocal discovery regarding the ARCA witnesses. Defendant hereby submits the following notice of reciprocal discovery regarding ARCA witnesses, Dr. Daniel Wolf and Dr. Andrew Rensler. I don't know how, I didn't get my drink before I came up. You guys, I mean, it's on the bingo card. Me drinking from my Waterloo can, it's like a thing. Like I do. I get thirsty. Some people have their giant, what do they call those cups? All my kids have them. The huge water cups with the straw, big metal things, the Stanleys or whatever. I don't do those. I'm old school. I drink right out of the can. All right. So request number 1, a complete statement of all opinions to be expressed by Daniel Wolf and Andrew Rensler and the basis and reasons for each opinion. This information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report. Read the report, Hank. Voir dire testimony and trial testimony of Dr. Wolf and Rensler. So that is basically here's what we're going to do for you. Read the transcripts, homie. There you go. That's their opinion. Their opinion, which is in the report, which you got at the same time that we got, and which they testified to verbatim at trial, is all in your possession, Hank. Just read it. Quit filing shitty motions and read the transcripts. Read the transcripts. Request number 2. All notes, reports, and materials relied upon either sick witnesses for reviewing this specific case. Request sick for materials is not. So when you see that, when you see sick, like if you're an old newspaper reader or you like to read articles, that means that Hank misspelled something in his requests. It's just a little gut punch. Just like that little detail there. That's just a little, like, I wouldn't even call it a gut punch. I'd call it like an ear flick. You know, there, you like that? There you go, Hank. So request for materials is not limited to the expert's report. The Commonwealth is requesting all materials relied upon in review, even if the materials are not part of the expert's report or opinion at trial. Response. All materials reviewed by Dr. Wolf and Dr. Rensler were listed in ARCA's report. The U.S. Attorney's Office formally authorized the defense to independently retain ARCA and produce additional discovery to the experts for the review on March 26th of 2025. Does he mean 2024? Maybe. Maybe. Possibly. I don't know. Maybe it is this year. Probably is this year. That same day. Yeah, it's got to be this year. The defense provided additional materials to ARCA, including Welcher's report for potential rebuttal testimony. So yeah, it's got to be this year. So all material were immediately produced to the Commonwealth in reciprocal discovery. Request 3, a copy of all materials provided to ARCA, LLC, Daniel Wolf, and Andrew Rensler, or any representative of the United States Attorney's Office by any member of the defense team or by the U.S. Attorney's Office. The request includes all materials, including written, documentary, video, witness statements, and witness is produced. So, response. All materials provided to ARCA by the defense have been produced in reciprocal discovery. You already got it. A copy of the grand jury subpoena issued by the U.S. Attorney's Office to Attorney David Yannetti, dated November 22, 2022, demanding production of, quote, all materials produced in discovery to date by the Commonwealth in the Commonwealth v. Karen Reed, as well as all relevant investigative material was produced to the Commonwealth in reciprocal discovery. Pursuant to that subpoena, the defense produced the discovery included in the notice of discovery 1-47 to the U.S. Attorney's Office. On October 22nd of 2024, the defense provided the U.S. Attorney's Office with discovery relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information in turn to the ARCA experts. The defense's understanding is that this information was not provided to ARCA, Dr. Wolf, and/or Dr. Rensler by the U.S. Attorney's Office. Footnote 1, a copy of the specific information produced to the U.S. Attorney's Office on October 22nd, 2024, relating to the reconstruction was produced to the Commonwealth in reciprocal discovery. So you got that all, Hank. And that's all relating to Hank's, in my estimation, slanderous accusations regarding Wolf and Rensler, and that they were using things that were secretly sent over by the defense to them to take into consideration without telling the Commonwealth, you know, oh, here's some under the table shit, man. Take a peek at this stuff, bro. No, didn't happen. Anything that they were going to tender, they sent it to the U.S. Attorney's Office first. But, you know, Hank's got this weird thing going on with the U.S. Attorney's Office. Never seen it before. It's bizarre. Hank doesn't seem to trust the U.S. Attorney's Office. Hank seems to have a real problem, real trust issues with the U.S. Attorney's Office, who are also prosecutors. What's going on with that? I don't know, but I love it. You never see that. It's probably because Hank is actually a mob lawyer, meaning he's a defense lawyer. And as you all know, we're all a little sus of the prosecutors. It's in our DNA. Take the boy out of the country. Can't take the country out of the boy. Boop. The defense's understanding is that this information was not provided to ARCA, Dr. Wolf, and/or Rensler by the U.S. Attorney's Office. Based on our best efforts and reasonable review of the files, all additional information relevant to this request was produced to the U.S. Attorney's Office by the defense, was provided to the Commonwealth in the federal materials both sides received from the federal government pursuant to our mutual TUI requests in February of 2024. The defense's understanding is that the only discovery materials produced to ARCA by the U.S. Attorney's Office were the materials listed in the report. Hank. Request 4, all materials provided to either witness after the conclusion of the defendant's first trial. Response, all materials provided to Dr. Wolf and Dr. Rensler after the conclusion of the defendant's trial have been produced. You got some. That's all there is. You got some. Nothing you're going to do, Hank. Nothing you're going to say, Hank, is ever going to change what their opinion in that report continues to be and was at the time that they made it. Nothing. All of the tomfoolery, all of the ballyhoo, all of the shenanigans that you have pulled will not change their opinion, which is that that vehicle and the damage it sustained was not caused by hitting a human being. It is what it is, dude. Deal better. Deal better. I mean, sometimes you just get bad facts, bro. I mean, you know that. You're a defense lawyer. We live in the world of bad facts, bro. I don't know why you're acting like you don't know what a bad fact is. And it's some shit you got to deal with. It's a good fact for Karen. It's a bad fact for the Commonwealth. Quest 5. Describe and produce any exhibits to be used as a summary of or support for the opinion. Response. All exhibits, excluding any exhibits necessary for rebuttal of Welcher's testimony, have been produced. You got it, Hank. You already got it. Quest 6. Describe all compensation paid to either expert for all work done regarding this case, including case preparation, testimony, travel, and expenses. Response. The only funds paid to ARCA to date is the $27,606.41, detailed on the invoice previously produced to the Commonwealth in reciprocal discovery. You got it, Hank. You already got it. Hank, you already have it. On March 26, 2025, the defense retained ARCA for the second trial. A copy of that retainer agreement and rate sheet was produced to the Commonwealth. Hank, you already got it. You got it, Hank. Quit asking for shit you already have, Hank. Request 7, provide any contracts, agreements, or documents relative to Daniel Wolf, Andrew Rensler, and ARCA LLC, discussing compensation relative to this case. Response. You already got it. All information responsive to this request has been produced. You already got it, Hank. Request 9, sick. Ooh, ear flick. That's what we're going to call those. That's where Hank had a typo in his legal pleading. Anytime you see sick, it's probably Eliza. I imagine Eliza Little is the one that's preparing these. Just giving Hank a little flick in the ear. Provide all written communications, including emails and text messages, between any member of the defense team and employees of ARCA LLC. Man, after this trial, I really want to get Hank Brennan on here. And I'm going to ask him flat out how he could do it. How did you become such a turncoat? Defense bar guy. Defense bar guy. Turns into just an absolute turncoat. He's like the worst of all prosecutor traits rolled up into one big turd. Okay. Request 10, provide copies of all testing not previously disclosed, including crash tests, video reenactments, and any other testing materials and results, regardless of whether the witness will testify to the information at trial. Let me guess. I wonder what the response is going to be here. Response. All information in the possession, custody, and control of the defense has been produced. You got it, Hank. Hank, you got it. To the extent additional testing is conducted in furtherance of rebutting the testing conducted by Aperture LLC, that information will be produced. What a great word. Forthwith. Forthwith. It's an old-timey one. That word stands the test of time. Forthwith. I mean, I'm assuming y'all are law nerds at this point. You got to love forthwith. You know what I mean? Shit's old school. Quest 11. Provide all written communications, including emails and text messages, between the U.S. Attorney's Office and employees of ARCA LLC. What do you guys think the response is going to be? You get one guess. Actually, you get 3 guesses. And only the first one counts. All information in possession and custody and control of the defense has already been produced. You got it, Hank. 12, provide all communications between the U.S. Attorney's Office and any member of the defense team as it pertains to the expert testimony in this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received from the U.S. Attorney's Office. All communications, this is the response, responsive to this request have been reproduced. Look, and this was made a hot minute ago, right? Like this response, this is them just like, so we've already heard the team telling them, you got everything, dude. You can keep asking over and over and over again. But what we're telling you is you got it all. You've got it all. So here's our response. You already got it. You got it, Hank. All communications responsive to this request have been produced. The TUI materials received by the defense from the U.S. Attorney's Office in February of 2024 are identical to the TUI materials produced to the Commonwealth. Oh, Hank. Request 13, provide a copy of all written requests that have been made by the defense team pursuant to 28 CFR Section 21 at SEC TUI regulations relative to either expert or ARCA. Response, all TUI requests relating to Dr. Wolf, Dr. Rensler, and ARCA have been produced. So there you go. No tasty tidbits in here because you know why? Hank's already got it all. He's got all of it. Got your signatures. And this is the attached request. That's all that is, y'all. So we went through those. All right, so that's the first one. My favorite part were the ear flicks. Oh, wait, I want to see who drafted it. See if Eliza's on top. Yep. Good job, Eliza. Nice little ear flicks to Hank. I mean, she didn't have to note that he had typos in there. But yeah, she did. And I'm here. Bukaki. Mandy. You guys close your ears. Put your earmuffs in. If you have little kids in the room, don't let them hear that.
Strike three. You're out.
Oh, Mandy's got new toys, kids. Mandy's got new toys. All right, Karen Reed. So this is the second thing. We've got, that's probably my favorite one. That new one is pretty good. The cat call whistle. All right. Commonwealth's motion to compel reciprocal discovery of ARCA witnesses and to exclude their testimony. He just will not give up. He will not give up. He was like, so we saw Hank this morning looking all disheveled, hair a mess. You know, he didn't have his hair jelly in there. Hank's not a dapper damn man. He's a fop guy. And if you know what that means, you know. He's no dapper Dan man. He's a fop guy. So the Commonwealth is seeking a viable remedy for the defendant's repeated Rule 14 violations and varying representations about the relationship. All right, y'all, hold on. I gotta let my dog in. I love him. Takes priority. Hold on. Be 1 second. Get up in your chair. Hop in there, buddy. All right, sorry, y'all. Okay. So the Commonwealth does not believe the defense has complied with Rule 14, nor the court ordered discovery. I don't have my phone. Allie's got it. Text Allie to please bring my phone back up and to bring a Waterloo. That would be amazing. Thank you. Let's see, this is modern technology. Like we're seeing it all in real time. So Mandy hits me. Is that you, Mandy, texting that to me? So Mandy's hitting me up on the stream, and I'm asking Mandy in our text to hit Allie up to bring my phone back up because I'm on a live with 2,000 people, and to also bring me a Waterloo because I'm getting frothy. All right. As Ali would say, moving on. The Commonwealth cannot wait until the middle of trial to properly prepare for cross-examination of the defense expert. Jesus, like that would be crazy. That would be crazy if something got produced in the middle of trial. Wouldn't that be insane? And God, imagine if it was fucking inverted. Oh my God. What would you do? That would be insane if that happened. That would just be outrageous. That would be outrageous conduct. But I digress. In addition, the defense's suggestion that it may request ARCA to conduct further review and or testing would be in violation of the March 6, 2025 reciprocal discovery deadline, Rule 14, and the court-ordered directives. Therefore, the Commonwealth's request. Oh, you know what? Is my mic low? I forgot to turn my mic back up after I had the boost on. Hold, please. I want to be appropriately loud for you guys because I know you love that. I'm going to go up to like a 79. Tell me if I'm good. Therefore, the Commonwealth requests that this court order the defense to comply and certify its discovery obligations or exclude the ARCA witnesses. What you got today, you got it there. You got it today. 2 ships passing in the night. This hot steamer right here, and then the thing that we just went through from the defense. If the court is going to allow the ARCA witnesses to testify, the Commonwealth requests a hearing within 1 week to inquire of the witnesses about their past relationship and interaction with the defense to identify any material the ARCA witnesses have received that are not listed in their report, and when they receive the materials, and the basis for any opinions outside the 4 listed in their February 2024 report. I'm all for that. I'm all for that. Because you know what? Wolf and Runcer don't have shit to hide. That's going to make him look like an absolute fool. I'm all about that. Bring it on. Let him ask his questions. Let him try to shame these guys. They're not going to get up there and lie. Not a chance. Not a chance. In support of this motion, the Commonwealth states the following. In advance of the retrial, the Commonwealth began requesting discovery related to the ARCA witnesses on December 5 of 2024, Exhibit A. The court allowed the Commonwealth's motion and ordered the discovery. Based on the defendant's repeated failures to produce discovery, the Commonwealth moved to exclude the ARCA witnesses on February 11, 2024. The court recently denied the Commonwealth's request to exclude the ARCA witnesses. You sniveling bastard. You've got everything. Like, dude, like, does this remind you a little bit of Shakespeare? The lady doth protest too much. Dude, you're showing your hand. We get it. It's bad facts for you, bro. You got to deal with it, Hank. Come on, you got your Welcher. What are you worried about? What are you worried about, Hank? You got Welcher. He's going to say some crazy shit. You're going to be fine. You're going to be fine, Hank. You're going to be fine. I mean, you're not going to win, but you're going to be fine. You'll live. The question is, can you look at yourself in the mirror after this trial as a defense attorney? If I'm a defendant in Massachusetts, I'm not hiring him. Not after the shit you pulled here today. That's directly from Good Will Hunting. That's that great scene with Ben Affleck where he subs in for Matt Damon at that interview where he's got the boat shoes and the white socks on. And he keeps saying, retainer. Your situation would be concurrently improved if I had $200 in my back pocket. Keep your ear to the grindstone. It's classic.
Do you like apples?
Hey.
We're side by side.
Hey. Oh, can you bring me my phone and a drink before you come on? Would you be like that
Yes, I
kind?
would love to. I literally just got off my Zoom meeting, so
You look so sexy. I just wanted to let you know that.
Yeah, thanks, babe.
Yeah.
All right, I'll run this up to you.
But I digress. Sorry, y'all. It was a.
Oh,
You
Lord.
got to give me some kind of high sign, Mandy, when you're going to play that, and I'll put my fingers in my mouth like I'm actually doing the.
So, did you guys watch any Aiden hearing today?
We watched all of it.
Damn it! I'm gonna have to like actually replay crew what you guys have.
Well, I'll
done.
so it was not in front of Canoni. It was in front of Sistitsky, Sisitsky, I think. Sistitsky.
Is
The
that the
judge,
guy that granted the motion in part?
yes, exactly. And so he gave Hank a little bit of a spank.
Ooh.
It wasn't a full-on whooping.
Right.
But it was a little bit of a, because he said, look, you seem to make representations to me in this courtroom that the only things that would be included in those were communications between Aiden and Karen. And I've come to learn that there potentially are communications between Aiden and his attorney, Mr. Brennan. And that's a big no-no. So Hank looked amazing. He clearly had been up all night. He clearly had fallen asleep and overslept. His hair was completely disheveled. Like I'm serious. Like it's like, and we've decided collectively. I decided for the team. He's not a Dapper Dan man. He's a fucking fop guy.
My hair.
My hair. I don't want fop. God damn it. I'm a Dapper Dan man.
All right, let me run you up your phone, babe.
Oh, and a Waterloo. I'm very frothy.
Yes, I'm on it.
Thank you so much. You are a delight. Okay. Okay. So based on the defendant's repeated failures to produce discovery, the Commonwealth moved to exclude the ARCA witnesses on February 11th of 2024. The court recently denied the Commonwealth's request to exclude the ARCA witnesses. At the present time, 5 days prior to trial, 5 days prior to the start of the trial, the Commonwealth has yet to receive the required and appropriate discovery and received notice on March 25 of 2025 that defense is contemplating the possibility of engaging the ARCA witnesses to provide additional opinions and conduct further testing analysis. Your Honor, I'm all about Ms. Reed and her constitutional rights. However, I don't want to be able to use these witnesses because they're against us. Okay, thank you. The defense's position that the material ordered in Exhibit A are not within their custody and control and therefore cannot provide is inadequate. Is it? It is what it is. She's already ruled. Res judicata. It's been decided, dude. Is this a motion to reconsider? Is that what this was? Did I miss that on the heading? No. Well, still not a motion. And it's, oh, thank you. Thank you. Kisses. Love you. All right, hustle down there. There it is. Get your bingo cards ready. There's the first canned drink of the day. Wow, I needed that. I was parched. Okay. So at the present time, I already read that one. I did that in Hank voice. Oh, wait, maybe. No, yeah, I read that one. So the defense's position that material ordered in the Exhibit A are not within their custody and control, and therefore they cannot provide is inadequate. The defense must comply with the court's order for the defense to call the ARCA experts as witnesses. Hold on, now my dog wants to leave the room.
Wait, what did he say? Hold on, I'm gonna what? As if someone can answer me. I don't know why I'm asking.
Well, they can answer in chat. No, like the dog now wanted to leave.
I saw that. I thought that might have been it.
Okay. The defense must comply with the court's order for the defense to call the ARCA witnesses as witnesses. Additionally, on March 20th, 2025, it was disclosed to the Commonwealth for the first time in open court that Attorney Yannetti had received a federal subpoena from the U.S. Attorney's Office to produce his entire case file.
Wait, which motion are you reading?
This is Hank's sniveling. Commonwealth's motion to compel reciprocal discovery of the ARCA witnesses or to exclude their testimonies. We already went through the defense's response for their discovery request. So we just did that. Now we're following up with this.
And this was filed after, or was
Today the 28th or the 29th?
Today's
Today.
28th.
It was filed this morning.
Can I ask you one more question?
Bobby, the boy just ain't right. Propane and propane
All right, sorry. Okay.
This is only staying alive, right?
Huh?
This recording is only staying alive, right?
What do you mean?
Not turning into a podcast.
No, this won't be a podcast. I've been acting a fool way too much. I had free reign because you weren't here to punish me for my indiscretions. So the defense's position that material order and Exhibit A are not within their control and custody, and therefore cannot provide as inadequate. The defense must comply with the court's order for the defense to call the ARCA witnesses as experts, or ARCA experts as witnesses.
So this is what Hank did after she instructed the attorneys to talk, figure out exactly what they need.
Nanook needs to make up his mind.
I mean, that's what I heard them saying, is like, all right, I want you guys to confer and figure out exactly what you need. And instead, he just tries again to exclude them. I mean, how many times are you going to ask the judge to exclude? I'm sorry, I'm not asking to exclude these witnesses. How many times is he going to not ask to exclude the witnesses? I mean, this time he actually literally asked. So
yeah,
it can't be like, I want them to be able to call their witnesses, but can you exclude them?
Right. Yeah, I echoed that same sentiment already, babe. It's like he just keeps asking the same shit. Like, I'm like, dude, deal. They're coming in. You got a bad fact to deal with, homie. You know, I was like, dude, you're a defense attorney. You live in the world of bad facts. Like, why are you acting like this is like a bad fact that the Commonwealth's gonna have to deal with? That they've got two banger witnesses that were hired independently. As much as you want to make them seem biased, they just aren't, because the report was generated before anybody had any communication with them. I mean, it is what it is. All right. So additionally, on March 20th of 2025, it was disclosed to the Commonwealth for the first time in an open court that Yannetti had received a federal subpoena from the U.S. Attorney's Office to produce his entire case file. On March 25, the defense further disclosed for the first time that the subpoena attorney Yannetti was referring to was an ongoing federal subpoena. On March 2025, or on March 25th of 2025, the Commonwealth was informed that discovery produced to the defense was in turn being provided to the U.S. Attorney's Office in an ongoing manner and included in the entirety of the Commonwealth's discovery referenced in Notice of Discovery 1 and through Notice 57, footnote 1. Notice 57 was provided to the defense on January 30th of 2025. Okay, the Commonwealth still seeks the following discovery: all bills, invoices, contracts, retainers, engagement letters, or payments that have been created for the defense of Karen Read or provided to or from the Karen Read defense team from March 1, 2024 to present. 2, all emails, letters, or any written correspondence, including text messages at any time between any employee of ARCA LLC and any member of the Read defense team, including Karen Read. All phone ledgers evidencing phone calls or text messages between any employee of ARCA LLC and any member of the Read defense team, including Karen Read, at any time. All written communications or summary of oral communications between any employee of ARCA LLC and any member of the Read defense team, including Karen Read, relative to any facts, claims, documents produced, or any other information about this incident that is not listed in the February 2024 report.
And all attorney work product. Thank you.
Yeah. And you know what, dude? Hank, here's the deal. I'm gonna say this so that a 5-year-old can understand it. The report was prepared before either side had any idea that they were doing the work. Do you understand that, Hank? All of this shit that you're asking for can never, in any way, shape, or form, ever change what was written in that report prior to either side knowing that they had been engaged by the Department of Justice, Hank. What do you not get about that, dude?
Well, I thought you're allowed to take depositions in Massachusetts.
I'm thinking no.
Oh,
Because
I'm confusing it with
Indiana.
Yeah.
Yeah.
I mean, that's what cross-examination's for, buddy. You can't just ask a bunch of questions in your discovery request. The source of all information about DNA. He's asking like a request to admit or an interrogatory. This is not what reciprocal discovery is about. The source of all information. So what are you asking them to write out an answer to you? This is how he was given this. That's not what this is for. What is wrong with this guy? And
he's a turncoat. That's what's wrong with him.
I kind of hate when you call him a turncoat because there's a lot of times where a defense attorney has to be a special prosecutor.
Yeah. Okay.
So I just want people to know that's not what we're calling a turncoat.
Correct.
We're calling, right, the way he is handling it.
That's right.
He's
He's
stepping
taking
all over.
what you missed it. Yeah, he's taking the worst aspect of every prosecutor and he's rolled it up into one big turd sandwich and he ate it. And now he's just puking it all out. Like everything that you kind of hate about every prosecutor that you kind of hate for things that they do that are shitty. This guy is employing all of it. All of it.
He's like, "Oh, I'm going to do all these things.
I'm going to be the worst prosecutor in the history of prosecutors. I'm going to do all the things that they've done to me because I just want to see how it feels." He's a mob lawyer. Shame on Hank Brennan.
I mean, we know a mob lawyer that you probably could not pay enough to act as a special prosecutor.
I tend to think that maybe he'd do the exact same thing. Like, I've been wanting to try this forever. I want to play all the dirty tricks that I can. All right. So 5, a written summary of all testing and findings that were conducted by ARCA employees Scott Klein, accident reconstructionist, and Jeremy Robbins, mechanical engineer.
So now he's asking for things to be produced that don't exist. Like he's saying, I want someone to create a written summary of all the testing and findings that was conducted. It's called their report, buddy. That's what you get. I don't understand what the hell he thinks he's doing.
So in my mind, there's a guy named Scott Klein that may have done like an accident reconstruction thing. I want that report. I'm not sure that it actually happened, but I think in my brain that it might have. So I need them to produce that immediately. We're 5 days out from trial.
And I only say it's not like he's actually looking for the written summary. He knows damn well a document doesn't exist because otherwise it would just be all versions of their, written report, any amended report, any preliminary report, like nobody, he's asking them to produce things that he knows damn well doesn't exist. Like he's almost instructing that they create it, which is what he went back and did, right? He's like, we don't have a chain of custody, so we should create a chain of custody, and I'll go back and kind of do that now. Where if he just hadn't done it, it just would have been, well, you guys never created a chain of custody. And then,
right.
Well, you
exactly.
never produced a summary of this guy's blah, blah, blah. So
right.
Do that.
And he's continuing. He just keeps wanting to put it on Canoni's on her bench. She just wants to keep sliding it in front of her in the hopes that she's going to change her mind. I mean, it's not happening. It's like, this is all, as you said, this is all ripe for cross-examination. Have at it. And he wants at least a week before they testify, he's asking for them to be voir dired so that he can grill them on all their potential bias shit. Have at it. Have at it. I'm all about it. I'm like 100% secure that these guys can hold their own with Mr. Hank Brennan.
And again, he's asking for things of them that they don't have, that only
But the underlying theme, babe, is that nothing is ever going to change the findings in the report. I don't give a shit about any of this stuff. This is all just a bunch of hanky panky. See what I did there?
Yeah.
Okay. So the source of all the information about DNA and forensic evidence that was provided to Dr. Wolf and Rensselaer prior to their trial testimonies. 7, all data, photographs, videos of any testing, regardless of whether the testing is the basis for any opinions. This request includes all data and memorialization of any failed tests. A copy of the federal subpoena received by the defense team, referred to by Attorney Yannetti. 9, an exact copy of all materials the defendant provided to the USAO, including 1, a list of the content of all materials provided to the USAO. 2, the date of each submission, the date each submission was provided to the USAO. 10, an exact copy of all materials the defendant provided directly to any of the ARCA witnesses at any time.
Okay, that one they can 10 they can ask for.
Yeah.
9 is ridiculous.
Yeah.
The reason that they think that they need to know what the defense turned over to the USAO, I just, I mean, I don't know, maybe she'd say anything that they turned over that was turned over to ARCA might be relevant, but how would the defense know what, if any, material that I mean, again, I think they've already asked it of ARCA, what exactly were you provided? That's all they need to know.
Don't worry, back after this, we're getting to it. We're going through all 4 things that were filed this morning.
We still haven't gone over the Easter stuff.
Well, did that come in yesterday? Was that the Easter
Came in
thing?
after I think I might have done a live without you.
Yeah, you did.
Right.
That's when I was at the hearings, the oral
So it
argument.
came in after that. It was filed the day before, but it didn't hit the docket till after. There was one other thing that also didn't hit the docket. But sorry, finish the last sentence here.
Okay, the defense's TUI request to the U.S. Attorney's Office following the USAO's March 4th, 2025 letter and any subsequent responses if all the requested discovery is not provided to the Commonwealth, or a defense certification that each request has already been provided. The Commonwealth requests that the court exclude the ARCA witnesses. Yours truly, Hank Brennan.
I mean, she could definitely make them file an affidavit that's a certification that says I've turned everything over responsive to this request.
Okay, so we'll whip through Hank's affy. This was the attached
skip,
affidavit.
like his name and stuff.
Okay, so he was appointed in mid-September of 2024. The Commonwealth sought and obtained a court order for discovery pertaining to ARCA witnesses on December 5, 2024. Commonwealth has repeatedly informed the defense and the court that it believes that the Rule 14 and court order discovery has not been satisfied.
Make it
on March
bigger.
20th, 25. Oh,
sorry. Just like if we're putting it up for people, they should be able to see it.
Agreed. On March 2025, Attorney Yannetti disclosed to the court for that he had received a subpoena from the U.S. Attorney's Office to produce his entire case file. Commonwealth was unaware of this information. Additionally, the Commonwealth has no idea what Attorney Yannetti provided the USAO, nor does the Commonwealth know what was provided to the ARCA experts other than what is listed in the group ARCA report. 6, after court on March 2025, the defense disclosed that the Attorney Yannetti was referring to an ongoing federal subpoena. Commonwealth now understands that the defense had or has been providing all discovery to the USAO in an ongoing manner, all material outlined in the Commonwealth's notice of discovery, 1 through notice 57. 7, on March 25th of 2025, the Commonwealth learned that the defense may ask ARCA to engage in further review, analysis, and testing, which could result in further discovery. 8, discovery deadlines have passed. The Commonwealth will not be able to fairly prepare its expert witness for new materials, testing, or opinions. Imagine that, getting something in the middle of trial.
But what I want to know is why the hell haven't they done that already? What the flip have they been doing between the first trial and this trial?
Who?
You've got all the defense.
So you weren't on for it, but it sounds like They just officially got the okay to themselves to retain ARCA.
I heard them say that
on the 25th.
I thought that they said.
I'm going to show you.
All right. I just remembered Hank saying at some point they got an email, or Yannetti saying at some point they got an email that says you are now able to talk to. We're done with ARCA. Do what you want.
Here you go. On March 26, 2025, the defense retained ARCA for the second trial. Copy of that retainer agreement and rate sheet was produced to the Commonwealth. So, but there was something that I remember preceding it that they finally got the okay from the
That
US
might be it.
office. No.
But I definitely heard Hank say that in court the day that he put up the
Here it is. So, the U.S. Attorney's Office formally authorized the defense to independently retain ARCA and produce additional discovery to the experts for the review on March 26, 2025.
Wow.
There is your answer as to why the defense didn't do it.
All right. Well, she's gonna have to let them get it in, and she's gonna have to let them. The question becomes, couldn't they have employed other experts to do what it is that they now want ARCA to do?
Right.
Did you finish reading, or did we cut you off and you went back?
Yeah. Well, I mean, I wanted to inform you with actual receipts as to why they hadn't hired ARCA yet.
No, I appreciate that. I just didn't know if you finished.
No, I've got these last two. Discovery deadlines have passed. The Commonwealth will not be able to fairly prepare its expert witnesses for new materials, testing, or opinions. The Commonwealth will not be able to prepare for new opinions beyond the previously provided report. So 9, the Commonwealth cannot adequately prepare for trial without all court-ordered Rule 14 discovery.
All right, and I want to pull this question up. B. May, thanks for your generosity. Can the defense ask for all records from the Commonwealth when they were expert shopping? So I think it depends. If they're, this is the way I perceive the difference between the obligation of the prosecutor, right? Because the prosecution has the obligation to turn over all helpful, I'll call it exculpatory or helpful information. So if the Commonwealth is expert shopping and somebody gives them a thing like, no, this indicates that the car didn't hit the body, they absolutely must turn that over, So if they give them anything that is contrary to their position, they must turn it over. Reciprocally, no. The defense can expert shop as much as they want. They can be told by one expert that this car hit this body, and then, talk to a different expert. They can just say, oh, well, I'm not calling this guy. It proves my client's guilt. And they don't have to turn any of that over. And in the federal courts, okay, they have, so think about when you've got an indigent defendant. The federal statute specifically calls for an ex parte hearing between the defense and the judge when the defense is seeking funds to basically, expert shop, to consult with an expert, because the prosecution has no right to know what the defense's theory of the case is. They don't have to share their defense at that point. And if they're never going to call that witness, they never have to give their, that information over. So that is the one time where the law says the defense is entitled to explore its defense without the prosecution knowing what they're exploring, and without the prosecution being able to say, well, you got funds for this expert and never called him. Why? You're not entitled to know why I didn't call him. That's my business. So that's why them saying, I want this other guy's opinion, no, you don't get the other guy's opinion. You're lucky you even know that there was a guy that they decided not to call. So I don't know if that directly answered the question. And then I'll read this because I don't know if you put it up, babe, or Mandy did. Thomas, how's that? Mail? But thank you for your generosity. And he says, thank you for your continued to cover this case. My wife loved Allie. How dare comment the other day. Any updates on the Richard Allen case?
No, no. We're just waiting for the.
It'll be a while.
It's going to be a hot minute. You be quiet
The
because they're
appellate
preparing.
process takes time.
It is a long, long process. Okay, so this is the defendant's motion for specific discovery. Okay, so this is going to be Eliza firing back, asking probably about the exact same things that some of our chat was asking about with relation to their witnesses. So
I
defendant
wonder
Karen
who
Reed,
filed first. Do we see? Can we see a time or no?
841 on theirs. They must have been standing. Well, everything.
He must have just processed them all, stamped them all at the same time.
Yeah.
And
They might have come. They might have come in overnight.
Right. In our courts, when you electronically file, the actual time that you submitted it is on there.
It is. Like there's 841, one was 846.
Yeah, but that's
you mean when you submit it electronically.
Right.
You usually see that at the top, don't you?
Yeah,
Like
but there's nothing here.
right. So I mean maybe these were hand filed. I don't know. All right, so defendant's motion for specific discovery. Karen Reed files the instant motion for specific discovery pursuant to Mass Rule Criminal Procedure Rule 14. On the eve of trial as a housekeeping matter to ensure discovery is complete in advance of trial. Defendant requests the Commonwealth to produce the following materials. 1, any contracts, agreements, records of payments, or documents relative to or discussing compensation of any experts in connection with the case. What's good for the goose is good for the gander.
But again, the defense is entitled to more than the prosecution is.
True story. 2, any recently discovered or previously undisclosed prior bad acts evidence of any witnesses that the Commonwealth intends to introduce at trial.
That's a little vague, I have to say.
Vagui?
Yeah, I mean, it should be specific as to what they consider a prior bad act, but
Vagui. Okay. So any recent discovery, I already read that one. Any information, including any oral or written statement or communication of any witness suggesting a reluctance or refusal to testify in connection with this case. Interesting. Any information, including any oral, were you going to say something?
I wonder if they had some reason to believe that has happened. Or if this is just, they decided that this is some kind of like standard. I mean, it's unusual. I've never seen a discovery request that asks for this, but I don't know if maybe this is something that they
Right. It's like they're getting at something.
Right.
And they're not telling us what it is.
Right. If they have some reason to believe, like, oh, I've heard the witnesses keep telling them they don't want to have to testify.
I heard things.
Right. But at the same time,
things.
That's something they'll be able to ask on cross-examination as well. But depending on what was said, I mean, anything a witness says to the Commonwealth, be it a prosecutor or a police officer, is supposed to be documented and turned over. Any communication.
I heard things.
What the fuck did you hear?
I heard things. I
was
heard
at the
things.
VFW.
Anybody gets that? Anybody gets that quote? I'm going to send you stickers, maybe.
I mean, it sounds like my cousin Vinny, but I don't think it is.
Definitely not.
Right.
However, that's a very good hint in terms of it's a very good hint. Somebody in the chat has to know what that's from. If you don't, shame on all of you.
Goodfellas?
No. I heard things. I heard things. I heard it's somebody will know.
Sure? Are you?
No, not my cousin Vinny. No, you got the right actors. See, I'm giving you too much. Now, if you don't know, you don't know. Boom. Smurf. What's the movie, though? And it's Jake LaMotta. Almost my namesake. It's one of the greatest movies of all time. Yes. Spoogs. Spoogie got it. Rage. Smurf got it. You guys, it was a tie. Rage. Exactly. Well done. I take it back. You guys are amazing. I heard things. Because Joe Pesci played Jake LaMotta. He was De Niro's brother in the movie.
Oh, other people guessed Goodfellas too before that.
Yeah, I mean, it was because of my Pesci imitation. You know what I
Yep.
mean?
All right, moving
All
on.
right, moving on. Moving on, as my dear wife likes to say. Any information, including any oral or written statement or communication of any witness wherein a witness suggested a reluctance or refusal to cooperate. Any information, including any oral or written statement or communication of any witness, including any promises, inducements, or rewards made to any witness in this case. Any information, including any oral or written statement or communication of any witness for what can be reasonably defined as quid pro quo in connection with this case. Any information, including any oral or written statement or communication of any witness, indicating an intention to or the possibility of changing any part of his or her testimony at trial.
Does seem like they're getting
They're
at
getting at
something.
something. They're getting at something. I heard things. The fuck do you hear?
I mean, the
I heard
same way I
things.
gotta be like, any information, what does that mean? Any information, but a written statement or communication, obviously. I mean, then the judge is gonna be like, but you further defined any information to be limited to.
This is not boilerplate language from a court document.
No,
This is
no.
not.
And this is why I started using, um, um now I can't think.
Smurfana, girl, I know. I know. Somebody posted on the Twitter, it was some Scorpions tune, and they were like, this song's 40 years old. I'm like, oh my God. I'm so fucking old. It's like, I remember when this video came out. I'm like that many old. Okay, a copy of all communications regarding any meetings between any witness with any member of the Norfolk County District Attorney's Office, including but not limited to Norfolk County District Attorney Michael Morrissey, Special Prosecutor Hank Brennan, ADA Laura McLaughlin, ADA Alan Lally, or ADA Caleb Schillinger, or any member of the Massachusetts State Police. As grounds therefore, the defendant states that the requests made herein are reasonable, necessary, and made in good faith, and are consistent with the objectives of Mass Rule of Crim Pro, Rule 14. So there you go. Asking for some dirt. They digging. I mean, what's good for the goose, good for the gander. Same shit. I mean, but they know something.
I was starting to say where they have including but not limited to. I started using inter alia because I didn't want them to try to say that I was limiting the definition the way Judge Cannoni did in the order on the motion to dismiss. When she talked about what they asked for, that they asked for video and audio, including any crime scene or other, or any other video taken in this case. And she said that that somehow limited it to crime scene. And I guess like technically inter alia would be the actual Latin is among other things instead of including but not limited to, which should mean the same. But
all right, so I'm going to go through this. Do you have that Easter filing up?
No, but I can
pull it while I'm going through this. It's going to be quick, and then you can buzz through the Easter filing, and then we're going to go eat breakfast together and hold hands, stare lovingly in each other's eyes. All right. So sadly, I imagine we probably have a bunch of cupcakes over here because sadly, Allie did not get to go to that undisclosed location known as the Sphere to see Dead and Company with Melanie and Andrea.
Or you
But
weren't, I don't think you're supposed to give them full.
they've said it on lives. Like
All
she
right.
asked you on a live, "Are you coming to the Sphere to see Dead and Co?" So, but she's good momming. We're doing a little spring break stuff with Scout, so I'm proud of her. She probably
I mean,
passed.
we've been running so ragged. I hadn't, good momming. I didn't even realize that spring break was coming up, and then I'm like, wait a minute, what? I guess
Yeah,
we should do something with our child
I'm
instead.
not gonna lie. I was not happy about the like. Oh, we're going to Florida, by the way. That got dropped on me yesterday, like a nuclear bomb. All right, so I, Elizabeth Little, do hereby depose and state that the following is true, to my knowledge and belief. She's a partner over at Worksman Jackson Quinn.
I mean, it just says that she thinks the request is reasonable, made in good faith, in the interest of justice. It should
I
be
was trying
allowed.
to kill time. Do you have Easter ready to go?
Oh.
Wow. Wow. Thanks for that summary there.
I forgot that I didn't save it, so
I think you
yeah,
got all
Tracy
like
sent it.
verklempt when I talked about some breakfast, huh? Hey, let's go get skillets.
Uh, let's see.
All right. While you're looking, I'll see if there's anything that's popped up. Sinead, off topic. Will you be going over the Lisk Fry hearing? It depends. Do you know, Sinead? Are they streaming it? Like usually New York courts don't do shit. If that is, or are you talking about the pleadings? I mean, either way, I'm gonna definitely get to it. Ooh, 2 docs emailed on the federale side. Oh shit.
I've got it up whenever you're ready. I should send it
Um,
to you too, because it's 12
let me
pages.
know in the chat.
Gonna
What
want to take turns.
the Easter thing?
Yeah.
So brother counsel's trial attorney brother, like his actual brother, because he calls himself brother counsel because that's what they call each other in Massachusetts. But is it his actual brother or is it another brother counsel? It gets very confusing. With vast federal experience, said he would strongly consider filing for judge recusal based on Dr. Crosby opinion and denial of evidence in motion to dismiss. His actual brother, yeah. I mean, okay, it's not going to happen. It's not going to happen. I mean, because at the end of the day,
I was kind of thinking the same thing though, just to tell you the truth. I was like, I feel like after what she wrote in the
because that but like, what's the legal grounds? Because it's within
I
her discretion to rule on it. You
I
just
know,
don't like the fact that she took the opportunity, as shitty as it was, to flamethrow the defense once again and didn't say a goddamn word about the bullshit and the shenanigans and the tomfoolery and the ballyhoo that the Commonwealth.
I was thinking about that I would want to, but then I would know it would be an exercise in futility, but I would
Right.
want to argue that the mental gymnastics the judge did to be, as you were calling her, a apologist for the prosecution, for the Commonwealth, that shows a level of bias, that she is not able to give a fair, true assessment of their conduct, the effect on the trial, the effect on the jurors. But yeah, it wouldn't be enough. It's got to almost be that she's outside of court, caught on video at the VFW, talking about how this is, bullshit.
Yeah, no, I mean, I don't disagree, but in terms of legal grounds, because frankly, I mean, you're aware that they had sought to recuse her early on in the case, right? And she went through the whole thing. Like, and I mean, that's kind of what got everybody on the like, this woman shouldn't be sitting on the case because she's too close for comfort. And she refused to take herself off. I thought that there were strong arguments there at that point. I mean, in terms of a record, and I guess so. I've got a question for you. If she's convicted, God forbid, on the manslaughter or If they're like, you know what, we're gonna throw the leaving the scene thing. Even though I don't see how you can convict on one and not the other. It doesn't make any sense logically. But my point being is if she were convicted, I mean, during the appeal, they're going to be able to hearken all the way back to that original motion for recusal of her based on bias. So wouldn't
That's
anything
what
on
that
the
original motion was, but I mean, they could just renew the motion. I mean, I think, and I'd have to look at Massachusetts law specifically, but recusal can't be based on her rulings in court. It's got to be based on like
direct
that, right?
well, originally it was conflict. It was conflict of interest, like 100% conflict.
That had to do with what?
I can't remember. Somebody in chat let us know. I mean, she like represented somebody. It was like a incestual legal relationship that like it made it inappropriate for her to be sitting on the case. Somebody in chat will let us know.
I mean, the argument could be made possibly that there is so much evidence of misconduct on the part of the Commonwealth that it should be venue should be changed um to a judge that doesn't sit in this county, that doesn't deal with these police officers and this prosecutor's office. That might be a stronger basis, and then kind of using Judge Cannoni's opinion to reflect that inability to make a fair, impartial assessment of their conduct and how egregious it is. But again, I feel like it would end up being an exercise in futility, and I don't know that it's necessary to preserve the record. I mean, I haven't given it a whole ton of thought, and I, usually like to research before I just off the cusp say something. But in my experience, recusal, like I said, it's literally got to be like she's outside of the courthouse saying some bullshit, or she says something like that uh Karen Reed is a real piece of shit. You know what I mean? Like something not about the merits of the case, not about the merit, the witnesses or like that.
Well, but there's also judges, for instance, if there is a conflict, say for instance, when they were attorneys, represented
Well,
somebody.
conflict, yeah, that's different. We're talking now about
Shrink.
potentially bias.
Sorry, we got the actual. So yesterday, we knew that the Fed side appeal had been denied, but Tracy just emailed the opinion. So
Yeah, it's probably very long and not. Well, I'll start going through the.
Okay, you read
Easter
through
thing.
Easter, and I'm gonna take a peek at
But I
this
kind of
thing.
wanted you to pop in at some point. So tell me when you're ready to start reading as well.
Oh my God, 50 more subs and we hit 40K. Come on, y'all. Come on, y'all. Like, what do we need to do to get you to sub? Cupcake in the house. We love cupcake. Love cupcakes. And we love Melanie. Like, I think the first show was like,
cupcakes in here.
Yeah, like Melanie's probably like, I don't know if she went live. I was thinking
She's traveling today.
I know. Is tonight the first show?
Oh wait, she traveled yesterday.
I think she traveled yesterday.
Yeah. Tonight is the first show. She might have gotten, she was contemplating going to one last night when she got in. So I don't know if she did or not. All right. Well, maybe the cupcakes can help us get to 54 more or to just 100,000.
Yeah. Well, Melanie hasn't even hit 100,000. That would be like
I don't care. Just jump. Just jump. All right. I was going to try to pull up some of those comments, but I'll start reading. All right. Oh, Lord, what am I doing? All right. So this is the defendant's memorandum in opposition to the Commonwealth's motion in limine to exclude Michael Easter's testimony. Now, I'm sure all of you remember that Michael Easter's former law enforcement, former FBI, who the state wants to call as as their Bowden expert to talk about the inadequacies of the police investigation. And Judge Cannoni asked Alan Jackson, do you have any Commonwealth precedent that you're allowed to call an expert to say that that they should have interviewed witnesses and they didn't follow this lead and the investigation was for shit, basically. And he's like, well, I have a hard time finding anything in the Commonwealth, but there is a ton in other jurisdictions. So this is the state's response after they did some more research and they're putting the stuff together. And it's going to show that essentially all those people that keep saying, people just like I'm assuming mostly like the really pro Karen Reed people, like, you can't just put an expert on to say that the police didn't do their investigation right and just like say whatever he wants to say. And then the judge like, well, then what if they do get does the state get to put on someone in rebuttal, another expert to say it was an amazing investigation? Where I wanted to say absolutely not. That's what they already did that through their police. Bob and Alan Jackson are both like, try it, do it. I'd love to see it, do it, which was very dramatic.
Yeah.
But I would have kept the legal position that no, that's
I
not
felt
what they
like
need to do.
Alan was watching our stream secretly because he really did echo what I said.
You mean like at the same time that you were saying
Yeah,
it?
I think he had it like in his lap and he was
Yeah.
down here like this.
He had you in his ear. Come on.
Yeah.
All right, that's a joke, guys, just in case.
Definitely a joke.
All right, now comes defendant Karen Reed and files the defendant's memorandum in opposition of the Commonwealth's motion in limine to exclude defense expert Michael Easter's testimony. The proffered expert testimony of Michael Easter is plainly admissible under Massachusetts standards for expert testimony and is relevant and admissible in furtherance of Miss Reed's Bowden defense. And they cite to Massachusetts Rule of Evidence 702, which mirrors exactly that of the federal, and Commonwealth v. Dreyer, a 2011 Massachusetts case, which they are going to summarize as we get into this. The investigation conducted by the Canton Police Department and Massachusetts State Police was deficient and failed to conform with the standard investigative policies and procedures. Defendant therefore has the right to present the expert testimony of Michael Easter, a retired and decorated agent with the Federal Bureau of Investigations, to testify regarding standard investigative policies and protocols and law enforcement's failure to adhere to those policies and protocols. I'd like to see some best practices right here. Failed to follow best practices, because it's more than just police policies and protocols. It's also best practices. All right, argument. Paragraph 1 or section 1, sorry. Massachusetts case law supports a defendant's right to call law enforcement experts in investigative procedures to advance a Bowden defense. The Supreme Judicial Court has made it clear that a defendant may introduce evidence that the police investigation was inadequate or unreliable. Pursuant to a Bowden defense, a defendant may introduce evidence regarding the police investigation in order to create an inference that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific tests or pursue leads that a reasonable police investigation would have conducted or investigated. And these tests or investigation may have led to significant evidence of the defendant's guilt or innocence. That's for that general proposition. And that is a direct quote from Commonwealth v. Wood, a 2014 case. Indeed, the defendant has, quote, the right to base their defense on the failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt. And they're again citing a Massachusetts case, 2006. That's also that case citing to Bowden. In Commonwealth v. Bowden, the Supreme Judicial Court held that a judge's instruction for the jury to ignore testimony about the non-existence of certain tests and other evidence when deliberating constituted reversible error. And then They include a direct quote from Bowden. The fact that certain tests were not conducted or certain police procedures not followed could raise a reasonable doubt as to the defendant's guilt in the minds of the jurors. The judge should not have removed this evidence from the jury's consideration, and in doing so, invaded the province of the jury to decide what inferences to draw from certain evidence. And then they also cite to a 2009 Massachusetts case for the prospect that, and this is a quote, although the defense in Bowden itself focused on the alleged failure of the police to conduct tests or follow regular investigatory procedures, a Bowden defense is not limited to these issues. And that's important. While Massachusetts courts have not been specifically presented with a challenge by the Commonwealth or a defendant regarding a defendant's right to present an expert on deviations from standard police policies and procedures in the Bowden context, courts have generally recognized the defendant's right to present this type of evidence and have taken no issue with the defendant calling an expert to challenge the adequacy of a forensic investigation. For example, in Commonwealth v. Wood, the Supreme Judicial Court denied a defendant's request to set aside the verdict on grounds that he was precluded from admitting evidence that law enforcement failed to investigate a third-party culprit, where there was no evidence suggesting the third-party culprit was in any way involved in the death. In doing so, however, the court reasoned that the issues of inadequate investigation was fairly before the jury because defense counsel was permitted to extensively cross-examine an officer about his investigation, 2, to argue in closing that the investigation was inadequate, and 3, through the calling of its own expert, extensively challenged the adequacy of the forensic investigation conducted by the police. Thus, the Supreme Judicial Court acknowledged the defendant's right to call an expert to challenge the adequacy of a forensic investigation. The issue presented here, i.e., calling an expert to testify regarding law enforcement's failure to conform with standard investigative policies and procedures, is no different and must also be admissible. I'm going to say it again. Why are they limiting this to standard investigative policies and procedures instead of best practices? Well, that's what you're talking about when you're talking about interviewing witnesses and how to interview witnesses. When you limit it to policies and procedures, standard policies and procedures, I feel like you're creating a box that you've got to establish what these standard policies and procedures are. Where if we're talking best practices, that's something that a former law enforcement officer can testify to, that this is best practices in our field. This is the way we do things. It's how it's done. It doesn't need to be in a box of standard policies and procedures. Moving on. In Commonwealth v. Dreyer, a defendant claimed, that's a 2011 Massachusetts case, obviously. A defendant claimed ineffective assistance of counsel based on counsel's failure to hire a forensic expert to testify regarding the crime scene investigators' failure to investigate certain gunpowder residue patterns and conduct additional chemical testing of gunshot powder discharge. In that case, the Supreme Judicial Court held that a trial court's failure to present an expert to testify about these investigative failures was not manifestly unreasonable because the proposed expert's affidavit failed to establish that the investigation and testing were, quote, reasonably necessary or appropriate for the police to conduct in order to investigate the shooting properly, such that a failure to conduct them might create reasonable doubt about a defendant's guilt. Indeed, under the rationale articulated by the Supreme Judicial Court in Dyer, expert testimony regarding law enforcement's failure to follow standard protocols and procedures or to engage in necessary and appropriate testing is not only admissible, it would be ineffective of counsel not to present this evidence. Similarly, similarly,
It's your kryptonite word.
Similarly, in Commonwealth versus Reynolds.
Similarly. That's the trick. Just say similar and then stick the ly at the end.
I did it.
Similarly.
Did it.
Oh,
Similar.
right.
Similarly, in the
There you go.
Commonwealth v. Reynolds, the defendant sought to call a non-expert police officer to testify in support of his Bowden defense, Commonwealth v. Reynolds. While the proposed witness in Reynolds, should say in Reynolds, was not an expert, the court, quote, agreed that with the defendant that he should have been allowed to call Dewan as a witness to show that the police investigation was deficient. He should have been able to call a witness to show the police investigation was deficient. The court goes on to assert the defendant should not have been precluded from eliciting evidence on the question simply because the Commonwealth asserted that the investigation was adequate. In other words, the defense should not be forced to accept the testimony of the Commonwealth witnesses regarding standard policies and procedures and whether they adhered to those policies and procedures, and instead must be able to present evidence in its case in chief establishing the investigation was deficient. Under the Massachusetts Rules of Evidence and relevant case law, where an expert is not testifying on scientific, technical, or medical matters, the Daubert-Lanigan standard and general acceptance tests are not required. Courts rather are encouraged to exercise discretion as to whether particular testimony would help the jury understand information that is not within their common knowledge and determine that the testimony presented is reliable, citing the Commonwealth case in 2001. For soft sciences and other non-scientific, non-technical, non-medical testimony, the court has broad discretion to determine testimonial reliability and may turn to Daubert-Lanigan for guidance, but may ultimately decide which factors might be applicable. 2021 Massachusetts case. Under this form of expert qualification reliability assessment, police officers routinely testify as experts in Massachusetts. Police regularly testify about the nature of drug transactions, drug use, and gang dynamics, information that may be in the general knowledge of a juror, but for which specialized knowledge would be useful. And they cite Commonwealth v. Little, a 2009 Massachusetts case, and include this footnote from that case, a quote, even in cases where the subject matter may be within the knowledge or common experience of the trier of fact, expert testimony will be admissible if, in the judge's discretion, it may be of assistance. And here's the point, people. They do this every day in every courtroom across the country where the police get on and say why they investigated someone, why they wanted to talk to someone, what led them there. I don't know why they think this is any different about why they didn't do it and what should have led them to do it. It happens everywhere. They use it to get around hearsay sometimes, where you can't say, well, Bob told me Allison did it. And then they just say, okay, so did you interview Bob Mata? Yes, I did. And immediately following that interview, as a
Allison did
result
it.
of that interview, did you go and investigate anybody? Yes, I did. And who was that? Allison Mata. So did they not just say that something Bob Mata said led them to know that I was the person that was, the perpetrator?
It's the workaround.
Right. But
So
it
here's
just
the
goes
workaround.
to show that, and their example of how, like, the cops talk about drug cases and gang dynamics and things like that. They're like, well, we know that drug dealers use their phones a lot. And we saw this guy on his phone, and then he walked to this corner, and we know drug dealers walk to corners a lot.
Based on my training and experience, I know that drug dealers have fuzzy dice on their mirrors.
But I
Remember
just
that
don't
one? We had a case where the cop actually testified that he knows drug dealers usually have fuzzy mirrors or trees that make your car smell good hanging from their mirrors. That was based on his training and experience.
fuzzy. Was it really the fuzzy or
It was,
just
I
tree?
swear to God, it was a fuzzy dice. I mean, fuzzy dice are badass. I'm gonna go buy some fuzzy dice today. What do you think of that? Whoa, she gone.
She gone.
Where'd you go?
Nowhere.
Oh, Mike's and Tom Jakes.
Yeah.
Yeah.
So I would like to see, and there's more to this that we're going to get to. So hopefully the defense, expounds on this, because I literally pulled up a case the other day, a federal case, where they talked about specifically the failure to investigate someone where a reasonable officer, would have found the information warranted interviewing that person or investigating that person, and that they failed to do so. So, which is not just policies and procedures.
What is
Uh,
Tracy counting down? I missed it. Is there a countdown going on? Brooklyn. Oh, happy day after your birthday day, Brooklyn.
Happy day after your birthday day.
Oh, we're having a shot party. Oh shit. 40,000. Woo!
Oh, yay.
Thank you guys. We love
All right.
you.
Thanks, guys.
Love you.
Yeah, no, we hit 100.
That is so. Hey, be happy with 40.
I am. I'm kidding.
Amazing. That's amazing.
Boom.
Thank you guys. We are
Thanks,
so
folks.
appreciative of that.
We are.
Of course, it'll drop down to like back to 39, 89.
What?
Or like no, like it'll drop down 11 after the live. That's how YouTube is. People are like, oh, like I'm not gonna stay subbed to that shit channel.
All right, don't give people ideas.
Oh yeah, that's me giving ideas. I just invented that idea. All right, keep going. I'm reading through this.
I know, because you haven't commented on any of this thus far.
Yeah, I'm getting through it.
All right.
So I want to see. I mean, I know what they're gonna say.
All right. So again, they quote this Commonwealth v. Little 2009 case also for the concept that admitting testimony about how drug transactions occur and indicia of possession for personal use as opposed to distribution. They cite to Commonwealth v. Mitchell 1999 case holding that an officer with 18 months of training 6 months prior was qualified as an expert on administration of narcotics. Well, I saw him put his fingernail up to his nose and then tilt his head back, and I thought I heard him sniff. I mean, what does this mean, the administration of narcotics? Somebody told me that they found paraphernalia, cocaine paraphernalia in their vehicle. And I was like, so they found like a dollar bill? They found a straw? Like, what exactly did they find?
Cash rules everything around me.
Dollar bills.
Cream.
All right. When police testify as experts, one of the court's primary concerns is blurring the line between specific testimony as a lay witness and more general testimony as an expert. And they cite 1998 Commonwealth case or Massachusetts case, quote, "It is easy for the line between specific observation and expert generalizations to become blurred in these situations. For this reason, when possible, the practice should best be avoided." Here, Mr. Easter is an expert in investigative procedure. He is a decorated agent with the FBI, Federal Bureau of Investigations, and is qualified by years of experience well beyond the experience of the expert in Commonwealth v. Little. And his testimony about proper police procedure and investigation, there we go, would surely aid laypersons on the jury in determining whether the investigation here was deficient. Citing the Little again and Mitchell. Given that he is only an expert witness, there would be no concern of blurring the lines between his general testimony as an expert and specific testimony based on his investigation. Citing back to Tanner. All right, so now section 2, which, Bob, do you want me to keep going, I take it?
Yeah.
That's fine.
Well, I mean, I
No,
can
that's fine.
read.
No, keep going. So in section 2, they take the Massachusetts Rule of Evidence 702 and the federal Rule of Evidence, and they point out how it's nearly identical and that federal law is instructive. And they're going to cite to all the federal cases where they have let this kind of expert testimony under Rule 702. So Section 2, Massachusetts Rule of Evidence 702 and Federal Rule of Evidence 702 are nearly identical, and thus federal law is instructive. But for one clause included in the Federal Rule of Evidence 702 that is not included in the Massachusetts Rule of Evidence, and in parentheticals says a plain reading of which makes the federal rule appear more restrictive than the Massachusetts rules, the rules are identical to one another. So now we go down to a footnote, and they start with Massachusetts Rule of Evidence 702, a witness who is qualified as an expert by skill, knowledge, experience, training, or education. Skill, knowledge, experience, training, or education may testify in the form of an opinion or otherwise if A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact and issue. B, the testimony is based on sufficient facts or data. C, the testimony is a product of reliable principle and methods. And D, the expert has reliably applied the principles and methods to the facts of this case. Then they go to Rule 702 in the Federal Rules of Evidence. And the difference here is that the federal rule says that a witness qualified by all those things may testify in the form of an opinion or otherwise if the proponent demonstrates to the court that it is more likely than not. And Massachusetts doesn't have that, which they're saying the intentional omission of that does make it appear as though the Massachusetts rule is um, less restrictive, allows more in. So they're saying that makes the federal rule more restrictive. And otherwise, the rest is identical. Then they add a footnote through 3 that says, quote, and they're quoting Massachusetts Rule 702, quote, the principal difference between the federal rules and the Massachusetts approach to reliability is that in Massachusetts, the proponent of expert testimony may establish reliability simply by demonstrating that the underlying principles or methodologies are generally accepted by the relevant scientific community. Returning now to the body, therefore, federal guidance on construction of Rule 702 is especially useful and persuasive. In numerous instances, under the Federal Rules of Evidence 702, law enforcement witnesses have been deemed experts in investigation and procedure. In the United States v. Paulson, the United States District Court for the Southern District of Ohio held that the defense may introduce expert testimony by former FBI agent on the adequacy of the government's investigation. Paulson, and that's a 2008 case out of Ohio. Paulson held that the expert testimony need not always be premised on, quote, scientific principles, and that, quote, experience-based testimony satisfies reliability standards. Disagreeing with the government's argument that the testimony, quote, will not assist the jury in resolving any issue in fact and therefore should be excluded as irrelevant, the court found that evidence, quote, tending to show inadequacies in the investigation would, quote, be probative of whether the government has made its case against defendants, as would experts' testimony on such matters. Further, the fact that defendant could have attacked the investigation solely on cross-examination did not preclude the defendant from introducing expert testimony on this issue. And they're still citing that Ohio case. And footnote 4 says, and it's a quote from that case, true, defendants can attack the government's investigation through effective cross-examination of the government's law enforcement witness. But just because defendants can achieve their objective in one way, e.g. cross-examination of the government's witness, does not mean that they should be precluded from pursuing that objective in other ways as well, e.g. putting on their own expert witness. I'm going boom because it's precisely what I'm saying when I'm reading Judge Cannoni's her opinion, on the motion to dismiss, where she's saying, well, the defense was able through effective cross-examination to show that the prosecution put on an inverted video. So there was no prejudice. But what about all the other things they could have shown if they had access to the metadata and if the video didn't look like it did? And just because they can do it in one way doesn't mean they're not all the other possible ways that they could have used that evidence goes out the window and doesn't matter. All right.
All right, wait, I got to give, so all of our new members, you are now family. And what we do over here is you get an family hug. We love you guys. Thank you, thank you, thank you. Thank you for getting us to 40K, you guys. It's amazing. What a feeling. Who would have thunk it when we started this little channel 18, 19 months ago? So we'd have 40,000 subs. It's a lot of people. That fills up like every baseball stadium in the country. When you think of it like that, it's a lot of people.
Yeah,
You guys
so
are amazing. Thank
I
you.
joke when I'm like, all right, now let's go to 100,000. That 40 is obviously great, and it really shows that people appreciate our content. They want a different perspective, and that they like what we got to say. So that feels good, and it does feel like we're bringing something to this, to the community, the online true crime community.
We love you guys.
Yep.
So family hugs all around.
Family hugs. Fine, I'll say it.
She did it. She finally did it.
All right, so where was I?
Do it, Megan. Do it. I'm waiting for it.
And you guys know I'm looking on the screen that has the
And if you guys are
motion.
wondering what I'm doing while he's reading, I'm reading through the opinion on the federal side
You
as to
can let
why
us
they
know.
denied it.
Give us a little summary.
Well, so I'm just highlighting. I'm gonna skip all the procedural stuff, the procedural history, how they got there, and I'm just gonna go right to their argument as to why they denied it. But you keep going with this, and
All right, so back to the body. They also cite a United States v. Stinson, Kentucky case where the court found that the experts, quote, opinions based on evidence relating to the competence of the investigation, such as that identified by the court in Polson, are relevant and permissible. They move on to in Thomas v. Lambert, a former Michigan State police officer who also worked as the Air Force Officer of Special Investigations and founded and ran an investigative group, was deemed an expert in proper techniques and reasonability of police investigation. And that's a 2022 Michigan case. The court further noted that specificity of expertise should primarily go to weight rather than admissibility. Another expert in Thomas, who was a police chief in Florida, had graduated from the FBI Academy and was pursuing a doctorate in criminal justice, was qualified to testify about investigative techniques, even though he was not an officer in the jurisdiction of the case. Both of the experts' opinions in Thomas were based on sufficient facts and data to meet the bar for reliability. Specifically, they compared actual police practices to model policy papers. The Michigan State Police's official orders and their own extensive investigative experience. And that's pretty important here. Also, their own extensive investigative experience. Because you're not going to find like a specific thing, I don't think, that says like when you find a deceased body on the lawn of someone who they were supposed to be on somebody's lawn in any event, that you should go into the house and make sure that it's not associated with someone in there. You should interview everybody.
That is common sense.
Well, I know. I'm just saying it's not.
No, I know you know. I mean, look, I'm here to tell you, if you wake up one day after you've invited a bunch of people to your house, and there's a digital trail of that, and one of those people that was invited to your home is dead on your front lawn, I'm here to tell you, you can bet your ass they're getting a warrant if you're not going to just allow them to come in and see what's what. And yes, a cop went in there, but they weren't searching that house. They weren't looking to see what was what. They were having a discussion, I think. But what I know is that if any of us had that happen, they're in your goddamn house.
So, babe, I think that your glutes weren't hurting as much as your ass just hurting because this thing is hard.
Huh?
My little bouncy chair. I don't feel my glutes working, but
Wait,
my
your glutes are your ass, hon.
no, but it just feels like I'm sitting on a hard seat, not like my muscles are actually
Well,
sore
because
or what.
you're like a little sprite, so like my ball squishes down. Like when I sit on it, it gets flat. Are you saying yours is remaining like a maybe maybe you do need to take like a squirt of air out of it?
Yeah.
Just pull that
Well, I
plug out.
decided, like I said, Mandy and I were talking that I was going to put it on the floor, but I got to get you to lower this mic for me because otherwise it's way above my. It's like
Okay,
I'm,
great.
no, yeah,
Oh yeah.
no, my head. All right, sorry guys. Turning back to where
Moving on. Moving
moving
on.
on. All right. Further, the experts in Thomas were called to comment on the reasonability and scope of the searches and seizures in a 1983 action. Even though opinions on reasonableness struck close to the ultimate issue in such cases, testimony about reasonableness was admissible. Here, Michael Easter's proffered expert testimony clearly satisfies all the elements set forth in Evidence Code Section 702. Indeed, his specialized knowledge will assist the jury in understanding, inter alia, law enforcement's failure to follow standard policies and protocols regarding crime scene management, chain of custody and handling of evidence.
Can we
Managing
mispronounce that as inter alia? Yeah. See what I did there? Alia.
right.
Wow. Wow. I really had to spell that one out for you.
I just didn't think it was funny.
Wow. Big dud. Big dud. I can't win them
Oh,
all. I can't
no,
win
you
them all.
can't. All right. So managing a chronological record, i.e., keeping a chain of custody, and timely and accurately reporting in connection with its investigation. What in the hell? So they're abandoning, failing to interview people, failing to separate witnesses, failing to follow investigative leads, accurate reporting. But none of that stuff changes the fact that how does any of that stuff, demonstrate that if they had done something different, that would produce evidence of her guilt or innocence? Why are they limiting it to these things? There is definitely case law. I've read it while I was researching for the Massachusetts specific case law. Just saying the failure to interview witnesses, the failure to follow a lead. His proffered moving on. His proffered testimony is the product of reliable principles and methods, which are based on his years of experience as a decorated agent with the Federal Bureau of Investigations and the stated policies of the Massachusetts State Police. Finally, his opinion reflects a reliable application of the facts of this case, namely information obtained directly from the Commonwealth and the police reports and logs associated with this case and the stated policies of the Massachusetts State Police. Thus, like the expert in Polson, Mr. Easter's testimony would use his years of experience to testify to standard investigative practices. Right, standard investigative practices, not all, why they limited themselves to these specific things up here, I don't know. And law enforcement's failure to adhere to those protocols and procedures or to follow best practices. That was me adding that there. Here, Mr. Easter's testimony does not reach the ultimate issue, Miss Reed's innocence or guilt, quoting back to Thomas. Rather, Mr. Easter would opine as to whether the investigative procedures employed by the Massachusetts State Police were in line with the stated procedures of the department and general best practices. Okay. Finally, the Commonwealth's suggestion that any examination or evaluation of police procedure and protocols would be speculative is belied by Michael Easter's report, which repeatedly references the policies set forth in the Massachusetts State Police Policy and Procedure Guide. While there may be variations between different officers, investigative styles, and all law enforcement agencies have standards to ensure competent, adequate, and ethical investigations. The suggestion that any assessment of the investigation would simply be a subjective opinion as opposed to an objective analysis based on professional standards and best practices is insulting to officers that spend years developing expertise in the area of investigation. Section 3. Babe, are you still reading?
I am.
Okay. The Commonwealth's authority regarding, quote, second guessing law enforcement officers is in opposite. So I'm just going to pause here again and say that I honestly feel like that they could have put in numerous other federal, they should have put a very long string cite in of numerous federal cases where ex-law enforcement or current law enforcement, whatever the case may be, are testifying that they failed to, that based on this information, I would have interviewed this person, and they didn't do it. And I, so I don't know why they didn't do it. Maybe they figure, like Bob's saying, it's kind of common sense that, when you get this information, you should follow up and investigate other people. But we also don't know what's in his report because that's not part of the public record. So moving on to Section 3, the Commonwealth cites 2 cases to suggest that expert testimony about investigative procedures would amount to, quote, second-guessing law enforcement. See Commonwealth's motion in limine to exclude defendant expert Michael Easter's opinion of the investigation at 2, which would be paragraph 2. However, these cases are not applicable. Both cases dealt with in-field arrests, where officers had moments to determine the legality of the arrest, citing the Marquez versus Albuquerque, which is a federal case, and Mendez Garcia, which is a federal case, both in the 10th Circuit. Here, there is no allegation that any steps police officers took were based on a fear of personal safety or immediate time pressure. That is a huge deal here. Like Brennan's like, I'm going to cite some cases finally. And then he cites cases that have no application to the facts in front of him.
Just says shit.
He just says,
King of just saying shit.
Right.
Ipsy Dixit King.
These are specifically cases, and because we read these in response to another motion, or we heard him argue it, I think, at the hearing, that these were cases where the court, I think that it was actually in the language of Brennan's motion. And I just remember being like, what's he talking about? This has no place here. So the courts were talking about how you put on an officer who had to make a snap decision, pull his gun because he saw somebody coming out around the corner, something over personal safety or immediate time pressure. And the court said, no, you can't put somebody on now that's in a, looking at things after the fact where there's no stress, there's no pressure, you're not on scene and something's happening, and second guess what these officers did when they had a split moment to decide something because of their safety or someone else's safety. That is not what's happening here, Brennan. Like, this is stuff that you are not allowed to do. You're not allowed to just put on cases that don't have anything to do with your case when you know that there's applications of the law that say that are contrary to this. You also can't just close your eyes and say, well, I didn't research that. I just looked for cases that said what I wanted them to say. I mean, that is all candor with the court. All right, moving back to the body of the motion. Rather, the question is whether officers followed proper procedure and protocols in instances in which they had ample time to make decisions. While certainly officers in this case may have faced pressure based on weather and other considerations, it is very distinct from officers making heat of the moment decisions in a split second. And I guess maybe if that's what Brennan used that for, talking specifically about the use of red Solo cups, I guess there's more of a reason that would be, or at least somewhat of a reason why you would look to cases that talk about immediate time pressure. But I think the defense makes a good point here that that's not like heat of the moment decision that deals with safety or something like that. They had to make a decision quick, but not split second. And again, I would have liked to see this be expanded beyond just police procedure, and more to the following of investigative leads and the failure to consider people suspects and to follow all that down until they were no longer a suspect. Section 4, the Commonwealth is free, oh Lord, to present rebuttal testimony. I hate this. I hate this. This is Bob, yours, and Alan Jackson's. Do it. Go for it. And I just don't think, I understand the point to be like, hey, good luck. But I don't think that they're allowed to do it. They even cited a case that said, you know, this is the defense. The defense in this very motion, when the defense is putting on this evidence to counter all law enforcement's testimony, which is basically saying we did good, we did right without using those words. But in any event, here's what the defense decided to say here. During oral arguments, the Commonwealth repeatedly implied that admitting Mr. Easter's testimony would create some sort of slippery slope. The Commonwealth suggested that if Mr. Easter's testimony is admitted, that the Commonwealth could bring in their own expert to rebut Mr. Easter's testimony. That is true. The Commonwealth is permitted to rebut a Bowden defense, specifically by presenting evidence as to why the police did not follow the line of investigation suggested by the defendant. What the Commonwealth suggests would be an impractical or impermissible consequence is actually an entirely expected result of a Bowden defense and is specifically supported by case law. So I've got to read this case, and it sounds like they're saying, you know, they could put on, so this I understand, that they could put on an expert to say, no, there's a perfectly good reason we didn't follow this specific line of investigation, but not put on an expert to just say, this was the best investigation I ever saw. And, you know, these officers made all the perfect decisions. But yeah, if they're specifically saying, they didn't follow an investigation suggested by a defendant, I don't know that would be by a separate expert, though. I can't imagine any world where a separate expert, the defense gets to call to say, no, I wouldn't have followed that, as opposed to just the actual police involved in this case. But maybe, I mean, I got to look at it. It depends on the facts. But when they were suggesting, oh, we'll just put somebody on to be like, well, I looked at everything and they did all things great and perfect. This was the best thing I've ever seen. So in conclusion, Mr. Easter's expert testimony is both relevant and admissible in support of a Bowden defense, and therefore should be admitted for the above reasons. Ms. Reeds respectfully request that this honorable court allow Mr. Easter's expert testimony to be presented by the jury. And I venture to guess that this defense thinks if they were to do that, I mean, basically it's why he said, do it, Jackson. I mean, that just gives more kind of fuel to the defense's position, like sort of like when they were complaining about Lally putting on a pre-buttal case. You know, like the more you've got somebody out there talking about, you know, he's going to have to acknowledge things were wrong. There's no ifs, ands, or buts around it. And even if he talks about why they might have made a decision such as the red Solo cups, he's also going to have to acknowledge that killed any possible testing. There's all this contamination, you know, that you almost might as well not have taken it, you know, possibly. But so I think the defense just thinks if they put on an expert, it shows that they're kind of scared of what the defense said, and they're going so far as to rebut it, and their ability to rebut it's going to be really awful. You still reading, babe? You're muted. Damn it.
Yeah, it's 22 pages long. I'm trying to get just kind of the
Well, I'll answer some questions while you do.
high notes.
Let's do it.
Okay.
Let's do it.
I'm close. I'm on 15.
All right, trying to find something, but I'll just do this anyway. Sinead says, and thanks for your generosity, they are arguing the nuclear DNA today. No live stream, but would love your take on the docs from today. Is that Koberger?
No, that's Hewerman, Rex Hewerman.
All right, well,
yeah, we'll definitely look at those. We'll definitely look at those.
You just keep reading. I'm doing this.
I am.
Okay. Larissa Harris, thanks for your generosity. Live with Lana would be fun. She has great subs. I know some are here. I think it would be a great live. Yeah, Bob's definitely interested in doing that. And thanks, Generation X, for your generosity. Lucy Farah says supposedly coaboated. Are we?
Maybe that was Bugs Bunny.
Yeah. Another new member. What'd she get, babe?
Oh no, Elmer Fudd. My fault. Oh, family hug. Welcome.
Thanks, Bev, for your generosity in gifting a membership. Thank you, CCR, for your generosity and being a member for 15 months. Congratulating us on the 40 subs. Thanks, Stephanie, for your generosity gifting memberships. Ann Piccolo, thanks for your generosity. She sent a Venmo.
She
love
did. We got
Venmo.
it. $40.
Wow.
And Tracy sent 50. Thank you, Tracy, for everything. Definitely didn't need to do that.
Our Tracy sent us money?
I'm assuming it was our Tracy.
How do you know which Tracy it was?
I'm assuming I'm assuming it was our Tracy.
Well, that was unnecessary.
I know. Yes, it was definitely our.
Well, thank you very much, but Tracy, don't do that anymore.
Yeah, don't do that. We
You
love
do so much for us. So
yes. Should be sending you $40. And she sent 50.
Unless he never sleeps. Thanks for your generosity and gifting 5 memberships.
We love you, Marissa.
Jim, thanks for your generosity, says while a phone to a face doesn't mean he's talking on it outside the Sally port. Right. Meanwhile, a phone to the face doesn't mean he's talking to it. Right. Yeah. We went over that yesterday. I mean, it's pretty hard to do anything with your phone if it's like this, other than be talking on speakerphone, because otherwise you're like here somewhere, you know.
That's how normal people do it.
Yes. And then he
no
says,
one wants cancer face. I mean,
congrats on your reading.
Oh,
congrats on.
Like I was just giving family hugs.
All right. Sorry. Congrats on 42 of the best to do it. Thank you, Bob and Allie. Thank you. Thank you. Cast Iron Mama asks, was the meeting this morning the only meeting today, or is there one with Judge Bev coming? My understanding is they're not in front of Judge Bev again until April 1st, which is Tuesday. I don't know if we thanked Jessie for being a member for 4 months. She's sending out family hugs, but thanks for your generosity.
Family hugs.
Feminine. Oh, feminine.
Feminine.
Right, got it. Became a member. Gave hugs to everybody. Lisa, thanks for your generosity. Should we grab our popcorn or adult beverage? I feel nervous. I'm going to have to rewatch the beginning so I can see.
Yeah, I went through all the early ones anyway, I think.
Live reaction video to the Karen Reed documentary, please. Oh yeah, we could do like a separate one where we're all just talking about that. I think that's what Lisa's asking. We can do that. Maybe we do that as our member feed, our member live. That'd be a good idea. And thanks, Lisa, for being a member, for your generosity. Julie, thanks for your generosity. Who does that robot think she is saying we cannot talk? GFY lady. I think that happened before I got on here. Streets of Bakersfield, thanks for your generosity. Sleuthy says, oh, you guys are talking about stuff earlier, so I can't help you there. Papa G, Appa P, inverted. I'm curious to see what the new attorney joining the team. Thanks a lot, Bob and Allie. So I saw a tweet from Aiden, aka Turtle Boy, who in that he said she may never see the inside of the courtroom. I'm assuming, and this is all an assumption, that like his lawyer, between him and his lawyer, they may actually know that, like, or I just found it curious that he said that, which seeming like, okay, wait, she might never actually be part of the trial, actively part of the trial team. But I don't know that that was just
I was getting the
supposition.
vibe that she might be a jury consultant. That's kind of what I was getting the vibe.
Right. And making her a member gives her full access to all the discovery. So thank you, Kimber. Kaylee, a bunch of new stuff. Thanks for your generosity. Hitting the docket. Yep, we got to that. Anita Whiteclaw, very generously gifted 10 memberships. Nola Mama, 13 months. Thanks for your generosity. 13-month member. Spank Hank. Julio, not in Bev's court now, Hanky. Thanks for your generosity. Yeah, that clearly was in response to what Bob called a spanking of Hank today. Hank, whiny objectifications. Thanks for your generosity. Hank can't snake his way in this court. Julio, thanks for your generosity again. I have grave concerns. Again, all talking about the judge in the earlier proceedings with Hank. Ginny Trioli, member for 13 months. This guy's getting all my angry going. Assuming she's talking about Hank at that point. Just south of history, thanks for your generosity. Defense attorneys are the real superheroes. I believe that, so thank you. I always say we are the unsung defenders of the Constitution. Nightclub, clubs, thanks for your generosity. Can you break down what happened? I'm hoping that Bob did after that, but if you guys still think there is more we need to, and it was that short, we could always watch it again. Pin it on Proctor. Thanks for your generosity. Tank team, 1 prosecution, 1 defense, 1 judge. Is that what they were saying they were going to do? Oh, we did all these, Allie. Thanks, Mandy. Did you guys do this one too? More documents, please, Bob and Allie. We are still waiting for the judge to rule on Easter. Let me look at some of our members' recent posts here. I got to figure out what you guys are talking about before I. All right, I'm going to go more current because I have to read too many to figure out what you guys are all talking about. I am buying time so Bob can finish. Bob is presently reading the judge's order in the federal case of Karen Reed so that he doesn't have to read you guys all of it. We can give you a summary and the highlights. So that's what we're doing now. We are not done. Is there an attorney in chat that knows about if Wolf can take the 5th or be impeached? If there's an attorney in chat, wait. Why would Wolf take the 5th or be impeached? What are we? Babe, you're. Let me see. How do I get to that thing? Down here? Hold on, guys. Damn it. I can't find it. Oh. Bob, you're muted. Bob, you're muted.
I wasn't trying to talk to you guys yet.
Oh, I thought I saw your mouth moving.
No, I was talking to.
Oh, Gloria.
Yeah.
Oh, damn it. I got to pin this one so I can get to it really quick.
Oh, why would Wolf need to take the 5th? He didn't. They're not saying he committed any crime.
Right. So, yeah, a witness can only take the 5th if their liberty's at stake with this question, but a witness can be impeached on just about anything. And maybe I just don't know what it is you're thinking. It's probably in one of the. Okay. Oh, a new doc dropped?
Another one?
That's what it looks like.
What is it? Coming fast and furious. Let's see.
All right. Well, I'll look for it. Have you finished this? Do you want to go over?
Yeah.
All right. So go over it real quick, like summary style, though. And I'll just say, oh,
Did you just go through you went through the motion and eliminate, right?
yeah. But
Okay.
Tracy sent us the defendant's. Wait.
I think she sent Easter and she sent the
Right. Defendant's
dismissal.
response to redacted presentation of Commonwealth's witness, Dr. Judd. This is a brand new thing that we didn't have before.
Oh, I didn't even get that yet.
Well, Tracy just sent it.
I know your email's faster than mine.
Oh, I don't have it. I was reading. I was just looking at what she's saying to us here.
Oh, okay. How long is it?
I'll look at it. You go
Okay.
ahead and
All right, so let's go through this. So this is the memo. All right. Just to catch you guys up, as you know, the defense filed a writ of habeas corpus over on the federal side. That was denied. They then appealed that decision. And the basis of it is that they're arguing that there was a verdict rendered in as to counts 1 and 3, which was the attempt red rum, or no, I'm sorry, the red rum second degree, as well as the leaving a scene while intoxicated. Those 2 counts. They're obviously primarily concerned not with 3, but with 1. So essentially, what they do is they go through what I just explained to you, that it was denied initially, and that they're appealing that particular decision here over at the First Circuit.
or make it summarize for us, though.
I am going to. That's
Okay.
what I'm doing, honey. What do you think I'm doing? Like on page 9.
Okay. All right. Because we got 11 pages of Alessi
Firing.
Yeah.
Okay. All right. Wait. This seems like the wrong goddamn thing. It's not the right thing. Hold on. I'm on the wrong document. I lost the right document.
We're sorry.
Click on
All
it.
circuits are busy. Please try again
You're witnessing tech wizardry right now.
That's why Mandy played that little soundbite.
I figured. Okay. Let me find it. Where the hell did it go?
Click on it below and then go back. Like, stop sharing. Is that what you need to do? Remove this?
I can't figure out, because I've got like Acrobat and the PDF thing on there.
Okay, so
Can
you gotta
I ask you one more
stop
question?
sharing your screen and then click on the actual document on your computer and then share screen again.
That's what I'm saying. I can't find. I have a million documents up on my second screen.
All right, guys. So Alessi did file a motion. It's talking about the the redacted presentation of the Commonwealth's witness. Remember, and that's Judd Welcher. If you remember, I don't know, I think they had 149 slides or whatever the case may be, and he was supposed to make things streamlined. Brennan had acknowledged that much of what he has in there can't be in there, like a ton of stuff. And then he decided to leave it all in there anyway. So the court gave Alessi 2 days to put together, whatever his opposition is to the testimony or the presentation of the Commonwealth's witness. So after Bob gives us this summary, we are going to get right to that.
All right, hold on. I've completely lost it. It's disappeared from me. All right, hold on. Let me see if it reopens when I.
Hopefully you saved it.
Wait.
With all your highlights.
No, I didn't, but it's got to be here. Oh, all right, I got it. Okay. Never mind.
Scared me. It's like to redo all that.
That would have been a nightmare. That would have been a complete nightmare scenario. All right. Okay. Okay, so like I was saying, they gave their initial procedural history as to why it's in front of them. So now they're talking about there's 2 different ways that they're attacking it, that being the defense. One that primarily that double jeopardy had attached, and they're saying that it's clear here that double jeopardy had attached. Okay, so that they're not going to even look at that. Now, the other ground is that the state court terminated jeopardy in a way that prevents reprosecution. So they then say, rather, the question is whether the court terminated jeopardy, i.e., whether the trial ended in a way that prevents a second trial. Reed offers two alternative arguments. First, that the court erred because there was no manifest necessity to declare a mistrial on the two counts. And second, that the jury effectively acquitted her on those two counts. Now, if you guys remember back to the first trial, when the notes started coming in, and they'll get into it a little bit in here, but Judge Bev, off the first note, she's like, there's not manifest necessity. I'm not going to give him the Tui Rodriguez charge yet. So everybody agreed at that point. The second note comes in. She reads it. She's like, all right, what do y'all think? She asks the defense. Defense says, we think there's manifest necessity. Give him the Tui charge. And the Commonwealth, if you'll remember at that point, said, no, we think that they can deliberate longer. Now, when you're kind of thinking about it from, and this goes to what Allie and I talk about all the time, when you're sitting there 4 days into deliberations, all right, and you're trying to figure out, like the longer it goes, in my estimation, I'm not getting warm and fuzzy feelings in terms of that they're coming down our way. You know that they're back there beefing, you know that there's an issue. But you know in your mind that there's at least some that are thinking that she's guilty on something, what you don't know. So at that point, you're kind of thinking as defense attorneys, you're like, all right, I mean, we don't necessarily consider a mistrial to be a win outright, certainly, but we do consider it to be somewhat of a win. So when the defense asks for the charge, they said, yeah, we think that there's manifest necessity has been met here. And now you have to give the dynamite charge or the Tui Rodriguez charge. So they then say a defendant generally may not be retried. These are general propositions of law for a charge if after trial begins, the court discharges the jury without the defendant's consent. But this right is not absolute. It is subject to the rule of manifest necessity. And that comes from United States v. Perez, a U.S. Supreme Court case from 1824. It's an old one. Under the doctrine of manifest necessity, trial judges may not foreclose the defendant's right to have that particular jury reach a verdict until a scrupulous exercise of judicial discretion leads to the conclusion that the ends of public justice would not be served by a continuation of the proceedings. The Supreme Court has defined manifest necessity as meaning a high degree of necessity. So, for example, a deadlocked jury is the classic example of a situation where declaring a mistrial is manifest necessity or manifestly necessary. And they're quoting Down v. State. So, relatedly, while a trial court's decision to declare a mistrial based on manifest necessity is accorded great deference, that deference does not end the inquiry and can be overcome, citing Washington. Because the decision affects the defendant's constitutionality or constitutionally protected interest to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorable disposal to her fate. Reviewing courts have an obligation to satisfy themselves that the trial judge exercised sound discretion in declaring a mistrial. For example, a trial court has not exercised sound discretion if it acts irrationally or irresponsibly. Reed argues that the trial judge made a precipitous decision in declaring a mistrial, emphasizing that only 2 minutes passed between the trial court announcing that it had received a third jury note by stating, quote, the jury is at an impasse, end quote, and discharging the jury. Reed also argues that the record suggests the court did not consider alternatives to declaring a mistrial or even discuss the possibility of a mistrial with the parties. In response, the Commonwealth counsels that we take a broader view of the relevant timeline. It argues that the trial court took careful steps throughout deliberations in responding to the jury's notes and only declared a mistrial when it was clear, after the third such note, that the jury was truly deadlocked. The Commonwealth further argues that federal courts have never required a trial court to take any particular steps when confronted with a deadlocked jury, and that the judge exercised sound discretion under these circumstances. In addition, the Commonwealth argues that contrary to Reed's suggestion, the trial judge was not required to ask the jury about a partial verdict or poll individual jurors, as doing so may have improperly risked coercing a verdict. So that's that 27B that when this was all going down that I was talking about, wherein it has language that the judge may do it or that counsel can ask that she do it. Now, the problem was that that didn't happen here. And again, like I talked about this last night a bit, it's easy to sit here after the fact, armchair quarterbacking that, you know, what Allie and I would have done in that courtroom in that moment of time, we can't know unless we were there. You know, like it's easy for us to say, well, because they had no idea. They had zero idea based on the notes that there was anything going on with respect to 1 and 3, and that they had reached some kind of conclusion unanimously as to either of those counts. Like you could be assured, had any of the defense team got even an inkling that that was going on back there, that they had reached a conclusion, which again is going to lead me to, and defense counsel did not prepare these particular, the writ of habeas. That's another lawyer entirely. And I think what was lacking in the argument was the fact that Jackson absolutely positively addressed the issue with the verdict forms with Cannoni. They had a real heated back and forth. And then finally she changed some language, but she didn't fix the thing that exactly turned out to be the problem, which Jackson said is, you're not giving the jury an option to select not guilty on counts 1 and 3. And she said, well, I don't need to, because if they're not selecting guilty on either one of those, we can just infer that they're finding her not guilty. Now we know that's not true. Now we know that she needed to add that box. Jackson was right. Cannoni was wrong. That box should have been there, because had that box been there, they then wouldn't have been confused about it being an all or nothing proposition, which is exactly what they thought. They thought they had to be unanimous on all 3, otherwise we're deadlocked. They did not realize that they could have said, not guilty on this one, not guilty on 3, but we're stuck on 2.
Right. You're absolutely right. If that box would have been there, they would have checked it and signed it. When the
100%.
only box you can check is guilty, what are you're signing it blank?
Right, because there's no option to select not guilty. So like, I don't know why they didn't argue that in this. I think ultimately they will. I think that,
Yeah, but they ultimately, I think, conceded to some sort of other change that they ended up doing, and then they reread the jury instructions to the jurors.
Well, she added a little wording, is what she did, and like, I mean, whether or not that concession was against their will, I don't know. I mean, like, God forbid, which like, it's moot. They're never going to be able to get her on second degree ever. They don't have the facts. It's a ridiculous charge. It's a disgusting overcharge, typical overcharge by the prosecution, as they do so many times. And the fact that they're going to continue, like I've said it a million times, the fact that they're arguing out of both sides of their mouth, because the issue, the difference between the two is intent that is required under the M2, and you don't need the intent factor with the manslaughter. That's the difference, the intent. And they're never going to be able to prove the intent, ever. We've heard all the evidence. They're not going to have anything new. Why do you think Hank is so desperately trying to comb through everything that Karen Reed says on every single interview that she gives, on every single documentary that's put out? Like that, that's why he's so desperate. He's so desperately trying to find her in a gotcha moment so that they can try to prove that intent for count 2 or for count 1 rather. So, but there is no mechanical rule or set of specific steps that a trial court must follow before declaring a mistrial due to the deadlock. Rather, the court must only take some step to ensure the jury is actually deadlocked. So recall that the trial judge received the first jury note about its difficulty in reaching a unanimous verdict after the jury had deliberated for around 19 hours. Upon receiving the note, the judge shared it with the counsel and heard their arguments on how to respond. As discussed, Reed's counsel urged the judge to give a Tui Rodriguez instruction, arguing that the jurors had exhausted all manner of compromise and were in an impasse. In other words, Reed's counsel encouraged the court to find that the jury had failed to reach a unanimous verdict following due and thorough deliberations. And then they cite Jenkins, holding that the giving of a Tui Rodriguez charge generally reflects a conclusion by the court that the jury's deliberations were due and thorough within the meaning of the then applicable mass gen laws. So this is particularly relevant because under mass law, once a quote jury after due and thorough deliberation returns to the court without having agreed on a verdict and is sent back out for further deliberation, but then returns to once again report a deadlock, the court cannot require them to continue deliberating unless the jury consents. So, however, after the first note, the court declined to give the instruction and sent the jury back to keep deliberating because it concluded that there had not been yet been sufficient time for the jury to have engaged in due and thorough deliberations. After the second jury note, Reed's counsel pressed a second time for the Tui Rodriguez instruction, arguing that the jury was hopelessly deadlocked. I forgot that they asked for the dynamite charge after the first one.
Right. I mean, the defense wants it sooner rather than later, since you can't ask for it twice.
Right. So the Commonwealth again argued it was premature, but the judge found that enough time had elapsed to conclude that the jury's deliberations were due and thorough, and thus proceeded to give the instruction. It was only after the jury's third report of deadlock, when the court was statutorily precluded from ordering the jury to continue deliberations without their consent, that the trial court declared a mistrial. So we find that the record read as a whole reflects only that the court acted diligently to avoid a mistrial. So then they kind of go through it again after the first note. And then they say only, so without that consent, and they're talking about the consent of the jury, the court would have been bound by the statute, the constitutionality of which Reed does not challenge, from compelling the jury to continue deliberating. Reed further argues, with the benefit of hindsight and the post-trial statements from some jurors, that the trial court should have considered, as an alternative to declaring a mistrial, asking the jury to specify on which charges it faced deadlock, or if its final note related to some or all of the charges. But our point of reference is the court's knowledge at the time it declared the mistrial. So we cannot say that a clear alternative Toribio Lugo was available to the court at the time of its decision for the following reasons. At that time, the only juror statements that the court had were the jury notes in front of it. The note stated that the jury was unable to reach a unanimous verdict. What?
I was just going to say, the notes in front of it, you could skip what they said because we already know what they said.
No, they had all the notes in. I skipped them all. I did.
Oh.
You know, they were deeply divided, fundamental differences, starkly divided, with some believing the evidence established the elements beyond a reasonable doubt, others finding the evidence did not sufficiently establish the elements beyond a reasonable doubt. The emphasized portions were the only time that the charges were mentioned, and the jury notes contain no indication that the jury might have reached a unanimous agreement on any individual count. Reed now argues that the court should have considered that charges might refer only to the lesser included offenses embedded within count 2, and accordingly, the court should have inquired into the possibility of a partial verdict pursuant to Mass Rule of Criminal Procedure 27B. That's that rule I was talking about. But the interpretation of the notes that Reed now advances only seems plausible in the light of the post-trial statements that did not exist and were therefore unavailable to the court when it had to make its decision. On their face, the notes appear to make a series of definite assertions that the jury could not reach any unanimous verdict. Thus, while it would have been within the court's discretion under Mass Rule of Criminal Procedure 27B to inquire into the existence of a partial verdict. There was no apparent need to do so here. So, nor was this alternative proposed by Reed's counsel. During the two opportunities, counsel was given to consult with the court regarding the jury's reported deadlock, or upon learning that the jury had returned to report an impasse for the third time, which you and I were concerned about. You and I were concerned that they had waived that because
So
they didn't
look at
bring
that
it up.
footnote.
So footnote 6 is we note that there is nothing in the third note that changes the calculus. Indeed, the third note, which says that the jury remained divided on the charges, is the note that is the most facially inconsistent with the possibility of there being a partial verdict. It follows that at the time of the court's decision, considering the information the court had before it, there was no readily apparent alternative to declaring a mistrial. So then there was a second argument, post-trial statements. Next, Reed argues that several jurors' post-trial statements established that the jury actually acquitted her on 2 counts, such that she may not be re-prosecuted on those counts. As an alternative remedy, she requests a hearing to ask the original jurors whether they acquitted her on counts 1 and 3. So whether an acquittal occurred. So this is, I mean, the law is just not in their favor here. A verdict of an acquittal is final, ending a defendant's jeopardy, and barring a subsequent prosecution for the same offense. Whether an acquittal has occurred for purposes of double jeopardy clause is a question of federal, not state law. So then we go down here. Reed argues that there was an acquittal because, quote, the ruling here was that the jury's unanimous and final decision reflected in the post-trial affidavits that Reed is not guilty. She offers no case law that directly supports her argument. Instead, she points to cases where the jury returned a verdict and the verdict form was later amended to fix an error. And that was U.S. v. Dotson and Stauffer. The Commonwealth counters that there was no valid jury verdict here under Massachusetts law. In particular, the Commonwealth emphasizes that under state law, a criminal verdict is effective only when affirmed by jurors in open court. And the Commonwealth also notes that federal law accords with this principle, citing Bluford versus Arkansas. So here, binding precedent is dispositive. In Bluford v. Arkansas, the Supreme Court considered whether an acquittal had occurred where, before a mistrial was declared, the jury foreperson reported in an open court that the jury had voted unanimously against guilt on 2 of the 4 charges, but then returned to deliberating. The court held that the defendant was not acquitted of those 2 charges based on the possibility that jurors could have changed their minds during the time that they continued deliberating, but before a mistrial was declared. In other words, even when the jury foreperson had reported in court a unanimous vote to acquit on 2 charges, that was insufficient because deliberations were ongoing and the verdict was not final.
So they just ignored her argument that here they were final. Deliberations had ended, and at the end of deliberations, they were all unanimous.
Right, but we're missing that key element.
I get it.
That it happened in an open court. It
Right.
wasn't a recorded verdict. So Reed's evidence is far weaker than the facts in Bluford. The statements do not describe when any votes were taken or whether such votes were preliminary or formal. Like Bluford, there is no sign that a final vote was taken. Meaning that if any deliberations continued after a vote, jurors could have changed their minds. Therefore, even if we assume that the jury unanimously voted in private that the prosecution had failed to prove its case on counts 1 and 3, the jury did not act on that view. There was simply no act here that could be considered a ruling or characterized as an acquittal. So then they get into where they had wanted them to have a post-trial hearing, bringing the jurors in, even if it was in chambers, to inquire from them. And they ultimately agreed with the district court that such a hearing would not be appropriate here. So that's it. So now the question becomes, and Allie might be dead balls on with the fact that if, in fact, Jackson waived that by capitulating to Judge Canoni's updated, because she was adamant. She's like, I'm not changing the forms. I'm not doing it. And then she changed the form. And then Jackson said, well, thank you for at least doing that, or something to that extent. So, he may have waived it, because otherwise I think it's a very powerful argument if it's not considered waived. But I like, can you make the argument as a lawyer? She's the judge. You had it out with her. She was clear she wasn't going to add the box.
And it was what their actual thing says. It followed their jury instructions, which is bizarre. All right. So, oh my God, I can't sit on this thing anymore.
Yeah, you
I need to
feeling it?
let some air out. No, I'm not. My muscles feel unworked, but it's hard on my tailbone.
That's what she said.
Mm.
What? All right. So how long is this thing?
It's very short,
Oh,
and
good.
I find it. So what they were supposed to do was talk together about a joint statement of facts to the jury. I don't know if they tried, but this thing is ridiculous. So this is Brennan's proposed facts. And we're going to go through them. So on the morning of January 29, 2022, at approximately 6:04, the Canton police received a 911 call reporting an unresponsive male in the snow outside a residence at 34 Fairview Road within their town. Okay, got no issue with that sentence. Second, officers responded and discovered the male party, subsequently identified as John O'Keefe, off the roadway in the front lawn area. What? No. That should say in the front lawn area. I think he's trying to use the words off the roadway just to get roadway in there to make it seem like how close he was to the roadway. Because obviously if he's in the front lawn, he's not on the roadway. So there, I would be saying subsequently he was found. Yeah, I would say actually the first sentence should say an unresponsive male party in the snow on the front lawn of 34 of the residence at 34 Fairview Road. All right. So the next sentence is officers identified 3 women with O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. I don't know that like that. I mean, I guess that one's fine. Okay. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to the residence in the early morning hours of this date. I don't understand, why. So then you're going to be like, okay, we want all the parties in the house and the defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton. And the defendant had driven with him to the residence where they were invited to an after, like you're going to get into all of that here. So I would be like, come on, get it straight. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to Good Samaritan Medical Center, where he was subsequently pronounced deceased. I don't think there's any issue with that. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe laid injured in the snow during a blizzard. What? Seems like they're kind of backing away from second-degree murder with that one.
Well, I mean, if they're going to say, well, she knew she hit him and then she left him there purposefully.
But what about hitting him purposefully?
I think the question for them becomes, was she aware that she struck him and then left him, whether she intentionally did it or not? Right? I mean,
Well,
even
that sounds like they're kind of if that were the case, it'd be changing their theory to be she accidentally struck him, but then left him there knowing he was going to die.
It's a different theory.
That he died.
It's definitely a different theory.
And we're not saying that that's what this says outright. I just find it odd that they're not saying the Commonwealth alleges that the defendant intentionally, struck Mr. O'Keefe with her vehicle. So again, this is like proposed statement of facts to the jury. And I'm surprised it doesn't say anything about the attempts made between the parties. All right, then they also have their proposed stipulations. So stipulations are where both parties agree and it's just going to be told to the jury or you know, or certain evidence you don't need, you're just going to stipulate that it's authentic and it can be admitted. So this is what they say. The Commonwealth proposes the following stipulations to be entered as evidence at trial. 1, in lieu of testimony by the keeper of records for different institutions where the Commonwealth obtained surveillance video, the defendant agrees to authenticity of each video. So I'm going to accept that to mean that the defendant does agree to it, and that should be the stipulation, which would be fine. In lieu of testimony, so that way you don't need to call the person for the library, and they could come in. Yes, we have a video camera. Yes, it records. Yes, that's it. Oh, put it up there. Is that the video? Yeah. Does it truly and accurately reflect what was on the camera? Yeah. All right, now it's admitted. So it skips that step. So paragraph 2, in lieu of testimony from the keeper of records at CF McCarthy's and Waterfall Bar and Grill, the defendant agrees to the authenticity of the restaurant receipts. Again, no issue there. In lieu of testimony by the keeper of records and in lieu of testimony from any defense counsel, the defendant agrees to the authenticity of her audio and video recorded statements made during interviews with reporter Gretchen Voss, Matt Gutman. So you got ABC, Boston Magazine, NBC, Ted Daniels at Boston 25. This stipulation also includes any recorded statement made by the defendant to American Broadcasting Companies, 2020. That would be Karen Reed, The Perfect Storm. Good Morning America, NBC Universal, including Dateline, The Night of the Nor'easter, and any statements of the defendant to Terry Muir on Unsolved Productions, Inc., or appearing in A Body in the Snow, the trial of Karen Reed, appearing on Investigation Discovery / HBO Max. So it seems that they're saying that the defendant has agreed to all of that. But I can't tell if they're asking for an agreement.
How many pages is this?
It's just a couple more. That's it.
Oh, it's a shorty because the new one going after Welcher's demonstrative is 11
Oh,
pages.
yeah. I had that up to do next. I forgot and did this first.
That one we could breeze through. It's basically Alessi just saying.
All right. Well, I'll let you do it. They had it up. In lieu of testimony by the keeper of records, the defendant agrees to the authenticity of statements attributed to her in a Part 2 Vanity Fair article entitled Karen Reed Tells Her Story, A Murder Trial in Massachusetts by Julie Miller, published on October 29th and October 30th. Now, wait, let's just think about this. The defendant agrees to the authenticity of statements attributed to her. All right. So, but here and all the other ones, the defendant agrees to the authenticity of her audio and video recorded statements. See, I'd be surprised that they were willing to say that the statements attributed to her are her, as opposed to, yeah, this is video from Vanity Fair. Yes, I agree to that. But when they're taking words out of context, when they're editing, I'd like to see if that's exactly what how the defense is interpreting that. Is that saying, because here they use the words, the authenticity of the statements attributed to her. And they use different language up here. Agrees to the authenticity of her recorded statements, but not. All right, 5. In lieu of testimony, the keeper of records, the defendant agrees to the authenticity of William Reed, Janet Reed, and Nathan Reed's recorded statements to Ted Daniels in Boston 25. I don't know how they plan to get that in other than, I don't get it. They can't put on William Reed, Janet Reed, and Nathan Reed to present their hearsay testimony, their hearsay statements to Ted Daniels. They just have to ask them the question, right? Did Karen Reed call you on the morning of? Yeah. And what did she indicate in relation to her vehicle and any concern she had about her vehicle? Well, she didn't say anything about her vehicle at all. Oh, well, did you make a statement to Ted Daniels saying that she called? No. Okay, now you get the statement in. If they say, yeah, she called and she said, and it's basically not inconsistent with what he told Ted Daniels, that's the only time they're getting that in. But the defendant agreed to the authenticity. I assume that's just in case they need it and that they're not trying to say that they think that they can get that on. That would just be, and you also can't put your witnesses on for the purposes of impeaching them. So I don't know why there's no argument about this here. So you can't put witnesses on for the purposes of impeaching them. So we'll have to see how that plays out. 6, the parties agree that the known DNA standard for John O'Keefe may be admitted without testimony from forensic scientist Sophie Hurrison that created the standard. The parties also agree that the standard may be used and referenced by analysts from Massachusetts State Police Crime Laboratory and Bode and UC Davis Veterinary Genetics Lab when they testify to their work, analysis, and conclusions based on samples of this matter, including making statistical opinions based on the standard of John O'Keefe. That's fine as well. In lieu of testimony by the keeper of records, defendant agrees the authenticity of her medical treatment records and medical treatment records of John O'Keefe and the admissibility of such records subject to appropriate redactions. That's fine too. It's like instead of the hospital coming on and saying, yes, those are our records. Yes, we keep them we standardly keep these as part of our business records, blah, blah, blah. In lieu of testimony of the keeper of records, the defendant agrees the authenticity of reports generated by the Canton Fire Department. That's fine and normal. In lieu of testimony from Andy Klain and Mike Maroli, the defendant stipulates that on September 23rd, 2024, what is that? Aperture LLC? Aperture?
Aperture, yeah.
Inspected, photographed, measured, and laser scanned the defendant's 2021 Lexus, John O'Keefe's 2019 Chevrolet Traverse, and area outside 34 Fairview, Canton. On October 2nd, 2024, the driveway and surrounding area of One Meadows Ave, Canton, Massachusetts, were photographed and laser scanned. So that's fine as well. Additionally, the Commonwealth proposes. So let's just see. Okay. What the difference here? When questioning witnesses for uniformity and efficiency, the parties agree to use the transcripts from prior trial that do not contain the sidebar conversations. Okay. Anything interesting there?
And what I've got?
No, and what I just said.
I mean, not beyond what you said. I mean, I like.
Pin It on Proctor says, sorry, I'm with Bob. Believe none of them and stipulate to nothing. I mean, that's typically what we do. We don't stipulate to anything, but some of these are fine, and we're not going to run into a situation where you hope they just don't have the witness and then they can't get it in. They're not screwing up here on that, and that's going to help this case go a lot faster when you're talking about so many months. But we do need to keep an eye on what's actually being stipulated to as far as her statements to the press and those edited.
All right, so I'm going to pull this one up real quick. Like,
I have it up, but I'll let you read. So,
yeah, we're gonna skim through this one. So, as you guys, because the longer we stay on the live, the more emails from Tracy we're going to get about. They're going to be filing motions and they're on the eve of trial, y'all. So
right.
This thing is going to, they're going to be firing everything that they need to, or they think that they need to.
And Bob and I are going to breakfast.
I mean, we're about about to blow it. So, so this is defense response to redacted presentation of Commonwealth's witness, Dr. Judd Welcher. And this is Bob Alessi just laying the hammer down. So if you guys will remember, we heard this argument, and then essentially this was about the 140 slide presentation that they were intending on putting up. And then Brennan's like, oh, I'm not really going to put all 140, and like, so Alessi's okay. If you're going to trim it down, we're cool. Let's wait and we'll see what they do. And then I'll respond in kind when we see what they're looking to throw up there. So this is his response to what they got from the Commonwealth,
including that they agreed to redact out all the the fact witnesses where he was talking about what's her name?
Who? Give me a hint.
Bukaki.
Buchanan?
No, who said Bukaki?
Oh, McCabe. I think Julie Nagel maybe said Buchanan.
And it said the alteration was include significant reduction of size of the presentation, which was originally 140, and to remove many defects. But then they didn't do it.
They didn't do it. So he says, yeah, the alteration was to include a significant reduction in the size of the presentation, which was originally 140 slides long, and to remove many of the defects. So then on the evening of the 24th of this year, Commonwealth produced the defense a supposedly revised presentation entitled blah, blah, blah. Unfortunately for the defendant in the court, the only real difference between the original presentation and the redacted presentation is the redaction of images of John O'Keefe from the hospital and autopsy. The original presentation, so then he cites that. The redacted presentation is still the exact same size and length, 140 slides, and none of the defendant's concerns with its contents, which the Commonwealth acknowledged and agreed with and committed to the court that it would resolve by removal, have been addressed.
Right. So he's making basically all the same arguments again, that he couldn't show his methodology. He relies on statements of witnesses that he shouldn't have, and essentially it should be, excluded.
Right. I mean, that's essentially what he's saying. So I mean, really my favorite thing in this entire thing is that Bob Alessi used the word recalcitrance. So that it's such a good word. It's so Bob Alessi. It's just so deliciously Bob Alessi. And it's like, it means that he's like obstinately non-cooperative. He being Brennan. So neither the defendant nor the court should bear the consequences of this recalcitrance and apparent attempt of the Commonwealth to yet again use the proximity of the start of trial to start decision-making that reflects such proximity rather than the merits of the arguments of the defense. In other words, it is the Commonwealth, not the defendant or the court, that should bear the consequences of the Commonwealth's recalcitrance here. So in all of the defendant's papers related to Welcher's proposed testimony and an oral argument, the defendant has raised the two following primary issues, which are fatal to Dr. Welcher's ability to testify as an expert. One, beyond Dr. Welcher's total lack of clear explanation or explication of his own methodology across the entirety of his proffered materials, neither Dr. Welcher nor the Commonwealth at any point discuss how Dr. Welcher's methodology is commonly accepted in the relevant scientific and technical community, or alternatively, how it meets the apt Daubert-Lanigan factors as is required for his certification as an admissible expert. And two, Dr. Welcher's proposed testimony veers far outside of the scope of his qualifications and expertise. For example, only drawing medical conclusions untethered to force calculations and crediting the testimony of other select witnesses.
So he goes on to say that the experiments that he did were done for litigation. They're not accompanied by the mandatory discussion of their acceptance in the appropriate scientific community or replicability in any of their materials. And they go on to talk about how he's not a medical doctor. And again, he says that quote, the totality of the evidence is consistent with the right rear corner of Reed's 2021 Lexus impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. So he goes on to say that they're impermissibly crediting the testimony of select witnesses, Julie Nagel, Richard D. Antiono, Ryan Nagel, Heather Maxson, Jennifer McCabe, Ian Whiffen, and that he's not allowed to do that. We already went over this. So they may not offer opinion regarding the credibility of another witness. Also, he shouldn't be able to rely on if he used that, then he shouldn't be able to rely on it. His whole opinion should be struck. Again, wish they made it more about more than just vouching for the credibility. But on the vouching for the credibility of a witness, explicitly or implicitly, they go on to say, and this is in the bottom on page 4, Babe, acknowledging the glaring problems with Dr. Welcher's proposed testimony, the Commonwealth stated on March 20th, 2025, any reference to witness testimony needs to be redacted. Opinions on credibility need to be redacted, but there are different demonstrations that we do expect. As far as extraneous commentary, no, that's not intended. It's not proper, and we won't try to use it. All right, but then they do it anyway. And then in the original presentation, they said they're going to use 140 slides or how many ever slides. The Commonwealth responds that no, that is, we were comprehensive in the production, the defense, so they could see all the data points, how it was produced, so that we've included. You see many of the slides is the camera showing different downloads. There is only a fraction of what we would show. And they said Dr. Welcher will not talk about opinions or testimonies of the witnesses, including all those people we just described. But he says, again, unfortunately for the defense and the court, contrary to that, he puts it all in anyway. And there's no discussion of his methodology in the entire redacted presentation, no reference to a potential methodology for the Daubert-Lanigan tests. And he doesn't specifically say that his opinions are improper because they rely on those witnesses. Even though he's not allowed to say it, why is he able to rely on it and coming up with his conclusion? I don't know. He concluded that defendant hit John O'Keefe because, quote, physical evidence at the scene, lacerations on John's right arm, skull fracture, and the absence of other fracture, that O'Keefe's skull fracture patterns and location are consistent with ground contact and not an assault. And the medical terminology.
Okay, dude. I mean, look, we can summarize this motion is saying that they didn't change shit. Brennan didn't change shit. He's putting the same bullshit up. So, I mean, he made representations in open court that he was going to fix it, and I'm hopeful that Judge Cannoni will hold him to that. I mean, that's the bottom line.
Right. And it's most significant that changes made from the original presentation was redacting nearly all images of John O'Keefe from the hospital and the autopsy and all the other things he said. It doesn't address the still deficiency of the presentation. And that he said he's going to reduce it to a fraction, and he didn't. On a final note at the hearing, Commonwealth said, I can be clear, there is no new information. The statement that Dr. Welcher's redacted presentation contains no new information is inaccurate. Slide 36 replaces a video of an aerial view of 34 Fairview with snow on the ground to a cartoonish mock-up of what appears to be a parking lot. And was not in the original slide. While the meaning of this change is unclear, slide 102 materially changes the language of the conclusion as compared to the original. And he says it's I put a footnote there of what it is. Compared to the original, the right tail light of Reed's 2021 Lexus was not broken when Karen Reed backed out of John O'Keefe's residence at approximately 5:07 a.m. No physical evidence to indicate the taillight was broken at this time. The new version says The right rear tail light of Reed's 2021 Lexus was not broken by contact between Karen Reed's Lexus and John O'Keefe's Chevrolet when Karen Reed backed out of John O'Keefe's residence. And approximately 5:07:58 a.m. on 129, no physical evidence to the whatever indicate the tail light was broken at this time. So, and I think the reason they changed that is because he's trying to say before, like, that it wasn't broken when it backed out, like, because of the way you kind of could see it. And now he's saying it's like his opinion that it wasn't broken. It should really say something like there wasn't enough force, and give the force equation. This would have been this and that would have been that to break the tail light at that, like, show its methodology, like Alessi's saying. He gave that whole mathematical thing when he stood up there before. Alessi did. And he says that slide 123 is changed. The meaning of the change is unclear. It doesn't address any of the concerns. And as a result, the changes, and there's your word you like, Bob, the recalcitrance of the Commonwealth to follow up on its own commitments to the court and to the defense. Defendant requests exclusion at a minimum of voir dire. And the conclusion is basically the same. The important difference here is that the Commonwealth acknowledges their own deficiencies in open court, yet ignores them to this moment. The Commonwealth must bear the consequence of its actions here, not the defendant or the court. All right.
We did it. We did it. All right. So a couple things. One, since this live ended up going 4 hours, no Felonious Friday. So that's not happening because Allie and I have to go to some Edgar Allan Poe thing tonight that might be fun. And then we're traveling tomorrow. So
thanks, Mandy.
And we are so excited that
Paralegal
we passed 40K today. We owe it all to you guys. You guys should all be breaking your arms, patting yourselves on the back, because without you guys, we're not here. Like, it's that simple. It's like, we feel like we've built a beautiful community here with awesome people. We do everything in our power to be all inclusive on all opinions. We're truly not an echo chamber. Anytime I see people being like, oh, I have the opposite opinion. Yeah, I mean, look, you're going to get a lot of defense attorney fans in here. So, if you're coming in with an opposite opinion, be prepared to stand your ground. That's all.
All right, let's go eat.
Did you thank everybody else?
I did.
Kyle?
I might not have thanked Kyle, actually.
Thank you. I'm offering myself as an expert witness. I spent an entire day in the MEs during rotations with Dallas. Surely that's as good as the dog trainer. Thank you. Thank you, Kyle. Appreciate you. Mello, family hug. If anyone hasn't seen Wants to Laugh and Aunt Debbie, love that. Jim Crotty, $5 hollow. Will Bev take notice that Weasel Face got spammed hard today? Doubtful.
And I did the rest of them.
Okay. All right. Is that it? All right, you guys. Mods, thank you so much. We love you. We adore you. We cherish you. We thank you guys for helping. All right, Mandy, come on.
Get it. It's over.
It's on a loop. I'm trying to think she's looping. It's like when she gets on a loop, it's terrible. But we love you, mods, because also without you guys, we're not here either. So just know that in your hearts.
Thanks again, Mandy and Tracy, too.
Mandy and Tracy, you guys are wonderful. Again, Brooklyn, happy day after your birthday day. And to all you beautiful subs, old and new, we love you guys. We thank you, because without you, I am just an old man.
Talking about a lot of cases.
Hot sun.